O'Neill, give me a thumbs up if you're in the booth. Okay, thank you.
Hey, good afternoon, Ms. Livingston. Thank you for your help getting everything ready.
Hey, Judge, thank you. You're welcome.
Let me see if we've got everyone we need. We've got Ms. Rivers, and I see Ms. Feely. Ms. Feely, is Ms. Wood joining us, or do you have all of the PD cases today?
I have all the PD cases today.
Okay, great. Well, why don't we get started? I have a list that's going to help me out from Ms. Livingston. If I go there, position 1, force output 1. Do one other thing. Hey, is that you, Mr. Camden in 4 South?
Correct.
Good afternoon, sir.
Good afternoon, sir.
This will be quick. Your lawyer, Ms. Feely, has already filled out the paperwork that we needed to talk about today on your behalf. I will get a scheduling order in place that will make sure your case moves along. And Ms. Feely will let you know she's going to get discovery in your case from Ms. Charles. That's the name of the prosecutor who has your case. And by the way, I'm Judge McBurney. I should have introduced myself.
Okay.
Ms. Feely will meet with you, share that discovery with you, and you guys will figure out what's happening next, okay?
Okay, thank you so much.
Sure. Do you have any questions about anything?
No, not really. I don't have any question.
All right. You are free to go from the booth. Thank you for being there.
Thank you so very much. Have a good day.
You too.
Thank you.
Good afternoon, Mr. Kuntz. Are you in 6 South?
That's correct, Your
Pardon me?
That's correct.
That's correct. I'm 2 for 2. Same situation as Mr. Camden, Mr. Kuntz. Ms. Feely has filed the necessary paperwork on your behalf. You actually have 2 cases with me. We've got a scheduling order in place in your other case. And so we're going to try to have this case move right alongside the other so that you can take care of both at the same time when you and Ms. Feely are ready to do that, okay?
Thank you, Your Honor.
You bet. Any questions about anything?
No questions, Your Honor. Thanks a lot.
You bet. Ms. Feely will be there to see you soon to figure out what's happening next, okay?
All right, thanks.
All right, you're free to go. Thank you.
Thank you.
And Ms. Feely, I didn't mean to be excluding you from any of these conversations. It just Ms. Nelson shared with me that you took care of the paperwork for these first 2 positions.
And I believe position 3 as well, Your Honor. I've seen them and gone over this process with them as recently as last week and actually yesterday for Mr. Camden.
Okay, I didn't realize position 3 was yours as well, but we're going to do the same thing on that one. Thank you. Hey, good afternoon, Mr. Davis. How are you?
Doing good, and yourself?
I am also doing good. Appreciate you asking. Mr. Davis, same situation. Ms. Feely, who's been very busy on behalf of her clients, has filled out the paperwork in your case so that we can move it forward. and she will come see you again once she gets discovery from the prosecutor. And we'll figure out whether we'll have a motions hearing or whatever's going to happen. You and Ms. Feely will talk about that. Okay.
All right.
Got any questions for me?
Yes. Is it possible the 2 months that I've been incarcerated in Clayton County, could that time be ran with this time, the 5 months that I've been incarcerated over here?
So it's a great question. Ms. Feely will talk to you about that. And so we're going to just do a hypothetical. Let's say you plead guilty to this case. I'm not saying you will. You may say you want a trial, but let's say you plead guilty and the sentence is 3 years to serve 6 months. If the months in Clayton County are somehow connected to this, like maybe you got arrested in Clayton and it just took a long time for you to get from Clayton to here, then you certainly will get credit for it. Now, if you serve 2 months in Clayton because, again, I'm making this up, you got caught for some marijuana in Clayton and did 2 months, and only then you came to Fulton for this, those are 2 months for Clayton business and not Fulton business. So it kind of depends on the circumstances, but Ms. Feely will be able to give you a pretty good sense of how that'll work out. So I don't want to say yes, but often the answer is yes, okay?
Yes, sir.
All right, you take care. You're free to go.
Thank you.
Thank you.
Mr. Hurd, is that you in 7 South?
Yes, sir.
Excellent. Good to see you again. Let me figure out who we've got on this call handling your case. Mr. Whitenauer is here. Good morning. Good afternoon, Mr. Whitenauer.
Good afternoon.
And is there an attorney representing Mr. Hurd for today?
Yes, Your Honor. Stephen Katz, subbing in for Mr. Harvey.
Mr. Katz, thank you for being here. I've added you to the spotlight so Mr. Hurd can see you. I'm pretty familiar with the case. It looks like we have a re-indictment that reflects what I've been hearing from the state, that as they have learned more about the situation through Mr. Harvey's work and maybe your work, Mr. Katz, but the defense work, they have repositioned the case such that the lead charges are now involuntary manslaughter rather than murder, which is a very, very different landscape for Mr. Hurd. But we are on for plea and arraignment and to talk about bond. That's what my notes say. Mr. Whitenauer, is that your understanding of what we're doing?
Yes, Judge.
Okay. Mr. Katz, are you prepared to do those things?
I am.
Okay. Well, let's start with the arraignment piece first. Is Mr. Hurd waiving arraignment on the new charges?
He is, Your Honor.
Okay. Mr. Whitenauer, are you moving to null pros the old case so we can get that off our docket?
Yes, Judge. We'll move to null pros 20 SC 176859.
Great. We'll take care of that. And we'll move forward with 22 SC. I guess bond needs to be heard for a couple reasons. One, Mr. Harvey for a while had been wanting to get the bond reduced because, of course, Mr. Hurd does have a bond, but now his bond applies to a different set of charges. And so there is no bond set for the involuntary charges or the simple batteries, et cetera. So it's doubly appropriate to talk about bond. Let's make sure we're on the record. Ms. Rivers, are you ready to go?
Yes, Judge, I'm on the record.
Great. Well, I will tee it up. This is 22 SC 183911, State versus Adonis Hurd. This is a re-indictment. The state has just moved to null pros the prior indictment of 20 SC 176859, which had charged Mr. Hurd with murder. Now he's charged with involuntary manslaughter involving a scuffle interaction he had with his then girlfriend that resulted in her death and Mr. Hurd's serious injury as they both fell from a high area in a MARTA station down to a hard surface below. Mr. Katz is standing in for Mr. Harvey, and we're going to talk about bond. Mr. Katz has waived arraignment for Mr. Hurd, so we'll get a scheduling order in place today, regardless of what happens with bond, and move this case along. Mr. Katz, when you're ready.
Thank you, Your Honor. I think the starting place in this case should be the previous bond that you set, because I think you concluded back in December when the murder charge was pending that he was not as serious a threat to reoffend or to intimidate anyone, or all those IALA factors, with the exception of fleeing. And I think you set a $200,000 bond at that time. The first $80,000 was set, was subject to the sheriff's 10% program. The remaining $120,000 was going to be a property bond that would be put up by Mr. Hurd's mother in her home in Fairburn, Georgia. When we did that, Your Honor, we thought that there was an excess of $240,000 in equity, and there may well be. The Fulton County tax records, and I think this is attached to our motion in the previous case to reconsider or to reduce, modify the bond, indicates that the value of the home is $205,000 and the equity is $61,000, leaves about $144,000. And Your Honor, we believe that a $140,000 bond, given the reduction in the charges, given any indication that he has substantial resources to flee, which he does not, given that any risk can be handled by an ankle bracelet, and certainly drug testing, given the underlying circumstances of the case. So given the reduction of the charges, he's a lot less person facing, say, 7 years for involuntary manslaughter. And I say 7 because he's been almost 3 years. Is a lot different from a person facing a minimum of 30 for a murder charge. And so he is substantially less likely to flee in the current circumstances. So a bond of 100 and where the property, which has an equity, minimum equity of 144,000, should be sufficient, Your Honor, to satisfy this case in its current posture.
All right, so you're saying 140? I didn't want to get the figure wrong. I was doing the old math for the old bond.
That's correct.
Okay, and the new bond of 140 would not be through an agency or through the sheriff's 10%. It would be secured by the property that we had been discussing before.
That's right. His mother's home, where he will also be living, Your Honor, which
Okay.
was pursuant to your previous order.
That was going to be my next question. So Mr. Hurd would still be able to live at his mother's address. That's that Pecan Wood Circle address?
That's correct.
Okay. And who else lives at that address? Mom and?
Your Honor, I am fairly new to the case. I do not.
Well, let's ask Mr. Hurd. Mr. Hurd, what's your understanding of who lives at your mother's address?
My niece, which my mother has custody of, and my stepfather, David Williams.
Okay, so your mom has remarried, her husband lives there, and your niece lives there.
Yes, sir.
How old is your niece?
7 years old.
Little. Okay.
Yes.
All right. Got it. Okay, Mr. Katz, anything else?
No, Your Honor.
All right, Mr. Whitenauer.
Yes, Judge, understanding that this court has granted bond previously, we would be asking that you set bond in the following amount: on counts 1 and 2, $40,000 each; on counts 3 and 4, $20,000 each; on counts 5, 6, and 7, simple batteries, $10,000 each, and on count 8, possession of cocaine, $5,000. That would be a total of $155,000. We'd ask that Your Honor include the previous conditions of the last bond, that being that the defendant be ordered to be fitted for an ankle monitor that he would pay for, that he consume no drugs and alcohol, be subject to screens through pretrial at least 4 times per month, that he possess no weapons, that he have no contact with the victim's family, that he not return to any MARTA station or property, and that he reside at that address, 495 Conwood, and that he be subject to a curfew from 8 p.m. to 6 a.m. Nothing further from the state.
So the total, I started writing down the numbers and then you went too fast, but the total math that you did, you believe adds to 105?
155, Judge.
155. So however I choose to break it down, your recommendation is 155.
Yes, Judge.
Okay. And how do you envision that being secured? You have a preference, you don't care. You just, obviously it's not going to be although technically with a bunch of these misdemeanors, it could be a unsecured judicial release. It will not be, so you don't need to worry about that. But how would you see it secured?
Well, Your Honor, I don't think that I'd have much objection to Your Honor allowing the defendant to post the counts 1 and 2 through pretrial, 10% and the 10% program, full county sheriff. And I think that then he would be able to handle the remaining counts, whatever amount you set, through the equity that's available in that property.
Okay. I'm just looking at the old bond, Mr. Katz. Okay, Mr. Katz, anything you want to add in response to what Mr. Whitenauer shared?
Well, Your Honor, the 10% would be less than the 10% on your original bond, but we would ask that you deem the equity in the home to be sufficient for the remainder of the bond if you set it to whatever you set it for. And that way, he's putting up they're putting up their mother's house. He's living there. He's not likely to flee, and given the circumstances now, Your Honor, and I think that the home and the 10% would be more than sufficient to guarantee his appearance.
Okay. Tell me about Mr. Hurd's willingness and ability to work as I think about who's paying for the ankle monitor. I don't want to put that cost. We happen to have county funded ankle monitors. And I know Mr. Hurd was injured. I just don't remember if the injuries were so severe that his thought is, hey, I'm not going to be able to work again.
Well, Your Honor, right now, we don't know. I think he would need some medical evaluation as to his ability to work. He was in the hospital for several months, as I understand it. And it was very serious injuries that he suffered. So before we make a commitment as to his health, I think it would need to be evaluated, and we could report back to the court about his health. We could also ask Mr. Hurd today about his health, whether he believes he's able to work. But,
sure. No, I'm going to do that. I just figured I'd start with you to see what I heard from you. So, Mr. Hurd, 2 questions. One, what kind of work were you involved with before you got locked up? And what are your thoughts about being able to get back to whatever kind of work you might want to get into when you get out?
I was doing traffic control, and to be honest, Judge, I don't know if I can do it or not, but I'm going to try for certain.
Okay. Do you have kids?
Yes, sir.
How many kids?
2 kids, 2 boys.
How old?
12 and 10.
Do they live with their mom?
Yes, sir.
Same mom?
They come to my mom's house on the weekends.
Okay. Do they have the same mother or different mothers?
Same mother.
Okay. And then they'd be able to see you at your mom's house on the weekends?
Yes, sir.
Okay. And their mother works? Is that how they've been supported while you've been locked up?
As far as I know, she's been doing Lyft.
Okay. All right. Okay, well, I will set a new bond and we have to start from scratch because it's a different set of charges. It's a different number of charges. And I think other than the cocaine, every charge is different. So I'm going to set a bond of $25,000 for both counts 1 and 2. So that's a total of 50. That will be through the sheriff's 10% program. And you will be subject to pretrial supervision at level 2, Mr. Hurd. So that 50,000, about 10% of it will need to come from friends, family, however that's going to work. That's not a small amount of money, but the good news is they get almost all of it back when your case is resolved. It doesn't go into the bank account of a bonding company, never to be seen again, but it will be returned minus some processing fees. So that gets us to 50,000, and then 2, 3, 4, 5, 6. I'm going to do 10,000 for each of the remaining counts. So that'll be a total of 60,000 additionally. So the total bond is $110,000. The remaining 6 counts can be secured by the equity in your mother's property. Your lawyer or lawyers will need to provide proof of equity in excess of $60,000, which it sounds like they'll be able to do. As long as your mom understands the consequences of you disappearing, Mr. Hurd, which is that then that property reverts to the county and your mom will be not only looking for you, but she'll be looking for a new home and you're not going to want her to find you, then we can go forward with this. You understand how that works?
Yes, sir.
All right. It will be a condition of your bond that you have no contact with Ms. Jackson's family, direct or indirect. Your lawyers can reach out to them, but you may not have friends reach out to them insofar as you and Ms. Jackson had shared friends. You will have a curfew of 8 p.m. to 8 a.m., meaning you'll need to be at your mother's house then, and we'll know that because you'll be wearing an ankle monitor that is paid for initially by the county. I will revisit that if it turns out you're working and if you're making some good money, then it may be your obligation to pay the ankle monitor, but initially the county will pay for that. So you won't be released until there is a county-funded ankle monitor put on you. And that'll help enforce the curfew. We can change the curfew if you end up getting a job and that job is at some funky time. So if you're working from 4 p.m. to midnight, we'll shift the curfew around so that you are able to get out and do that job. It will not be a requirement that you get to work right away because you're going to need to work through the health issues you've got and figure out if you can work what that job will be. I'll also add a requirement of no drugs or alcohol, and you'll be subject to 4 random drug screens a month while you are on pretrial supervision. The no MARTA, I understand the origins of that, Mr. Whitenauer. Mr. Hurd, do you have a way of getting around, or would someone have to drive you because of your injuries? Do you have a driver's license? What's your situation?
Somebody will have to drive me, but the job starts at 6 a.m.
Well, you don't have a job right now, do you?
When I get out, I will.
What's that job going to be?
Traffic control.
I thought you just told me you're not sure you can do it.
Yeah, I'm not sure I can do it, but I'm going to try.
Got it. Okay. So it would start at 6. You believe you can go back to the same job you had many years ago?
No, it's a different job.
And you've already lined it up?
Yes, sir.
Okay. But it starts at 6.
Yes, sir.
Okay. Then why don't we shift you? When would you need to leave the house to get there?
Around approximately 5.
Okay. Well, we'll shift your curfew to 7 p.m. to 5 a.m. So 7 p.m. to 5 a.m. You're at home with mom, stepdad, and niece. But 5 a.m. You're able to get out and about, go to that job, whatever. And again, we'll shift the hours if your job shifts. And how would you get to the job? Someone would drive you, or do you need to take a bus?
My mom.
Okay. Okay. And is she driving you because you don't have a license or because of your injuries you shouldn't drive?
I don't have a license. My license is suspended at the moment.
Okay, so you don't have a license and you should not be driving. All right. What I'm going to say is that you should not ride any MARTA trains. You may end up needing to ride a bus to get from point A to point B. I don't want the lack of public transportation due to the bond order preventing you from getting to work. So you need, Mr. Whitenauer.
I'm sorry, Judge, but I'd have to look back through the file, but I do have a recollection that Mr. Hurd may have been criminally trespassed from MARTA. So I would just.
Oh, MARTA he may not be able to go back anyway.
That is my recollection. I don't have that in front of me, but that would be, even if it's not part of your bond order, that might be a concern for Mr. Hurd.
Why don't we just do this? We'll just say no MARTA for now. And if, Mr. Hurd, your situation evolves where your mom's got to drop you off at a bus stop for you to work or do something productive, one of your lawyers can reach out to me. And if I need to modify the bond, I'll do that. But for now, bright line rule, no MARTA buses, no MARTA stations. Stay away from those. Rely on family to get you from point A to point B. Okay?
That'll work.
Mr. Katz, anything else on behalf of Mr. Hurd?
No, Your Honor. Well, actually, yes, the scheduling order, given Mr. Harvey's schedule, as I know it, is there anything you could tell us what you're thinking about in terms of that scheduling order?
Sure. My thought is that we put it on a trial calendar again soon. We don't need to reset to provide discovery, et cetera. Discovery had been exchanged already, and this was a case that was, I think it had been on a trial calendar, and then I learned that the state was going to be re-indicting. And so, of course, we had to arraign Mr. Hurd for that. But when I say scheduling order, I probably was a little loose in that term. I think what we'll do is put it on a trial calendar. That won't be until the new year as I look at what we've already mapped out for the rest of the year. So it will be on a trial calendar in the early new year. Mr. Harvey will be able to do what he's so very good at, which is file conflict notices if he's got conflict notices. I just can't tell you right now which trial calendar it will appear on.
I know he's specially set in a gang case in South Georgia, starting January the 3rd. That should be about a 2-week case.
Okay. Well, maybe we won't bump into that. If we do, then we may have to move this. It's now a new case with a new indictment. So we slip back in line in terms of taking priority with other matters. I am hopeful, given these new charges, that Mr. Whitenauer and Mr. Harvey may be able to sort something out, but we will keep the pressure on by getting it on a trial calendar sometime in the early new year. Mr. Whitenauer, anything else?
Nothing from the state judge, and that concludes my business before the court. I'd ask to be excused.
All right, before you go, Mr. Hurd, do you have any questions?
What's the total amount of the bond again?
$100,000. 110. It's 50 plus 60, so 110.
Okay.
Okay. But 50 of it is through the 10% program and 60 of it is secured by your mother's property, assuming your lawyers can put together the paperwork showing, hey, here's the equity in it. In other words, if your mom sold the house tomorrow, she would get at least 60 grand for it, wouldn't owe it to the mortgage company or anything. Then that is an adequate surety because we all believe that you wouldn't skip town and leave your mom homeless.
Right.
That's the right answer. Good. Okay. All right. Mr. Whitenauer, you're free to go. Mr. Katz, thank you for covering for Mr. Harvey. He owes you one.
He does. Well, he knows me a lot more than one, Your Honor.
Well, that's for you to settle with him. Good luck with that one.
Thanks a lot. Bye.
All right. Mr. Hurd, you are free to go.
Thank you.
Oh, definitely him calling me. I log off of this.
Hey, Dion, I'm going to mute you, okay? Mr. O'Neill, can you hear me? Can you, it says you're muted. That's weird. Mr. O'Neill, can you say something? Huh. Is booth 2 empty? The one right next door? I can't, because I'm trying to unmute you and it says you're unmuted on my little device here, but then you're not unmuted. And I don't know how else. Can you check to see if the booth right next door is open? South booth 2.
I'm in booth 1.
Ah, yeah, that was the issue. You were in booth 2. Okay. All right. And I had unmuted the wrong thing. All right. Can you hear me now?
Yes, sir.
Great. And we can hear you. Mr. Johnson, you available?
Yes, Your Honor.
Fantastic. Let me add you to the spotlight. There he is. Mr. O'Neill, Mr. Johnson has replaced your most recent conflict defender. You had Mr. Cladis for a while, and before that you had, I'm blanking on his name, and before that you had a female. You've had a bunch of lawyers. Mr. Johnson is sticking with your case. Mr. Johnson, this is a case where the co-defendant has already pled. We've actually gone through a couple prosecutors on this case as well, but it's trial ready in the sense that discovery's been provided. I know a whole lot about it. I think Mr. O'Neill, were you in state custody for a while and then you rejoined us? Am I remembering correctly?
I did 2 years. 2 years here, then I went to prison for a couple of months and came back.
Yeah, you had a revocation or something. That's how old this case is. So, Mr. Johnson, it's on for a status conference. I know you are still climbing the learning curve on a bunch of the cases in my division, but we need to give Mr. O'Neill some sense of what's happening next. You ought to have all the discovery if, and it's a big if, Mr. O'Neill's case file has gone from Mary Beth to the guy whose name I'm not remembering to Mr. Cladis to you.
Yes, Your Honor. I have some of this. I'm not sure if I have everything. I'm in the process of going through, so I don't really know what's missing. But if possible, I'd like to speak to the state, given the fact that you say that the other co-defendant has already pled out, to see what their offer would be in this matter, so that I could broach the matter with Mr. O'Neill once I'm able to get full up to speed on this case.
Sure. I'll have Mr. Hand reach out to you. Mr. Hand's going to need to learn a little bit about it. I'll tell you that there were fairly robust plea discussions if we rewind all the way back to when Ms. Hall was the prosecutor and Mary Beth, whose last name I'm not remembering. I thought it was going to work out. It is a case that is fairly compelling for the state based on the evidence that was presented to me at bond hearings and other hearings that we've had. You are a master defense attorney, but I think as you learn more about the file, you will see that this is a tough one to wriggle out of, given how Mr. O'Neill was apprehended, what state he was in, the van from which he emerged, et cetera. But you're going to need to connect with him on that after you talk with Mr. Hand. Mr. Hand, do you feel like you've become acquainted enough with the case to have a good conversation with Mr. Johnson? Not right now, but in the near future.
I do, Your Honor. And I would ask Mr. Johnson, if you can give me your phone number, maybe drop it in the Zoom or something. But multiple times I've thought to call you and I can only just send you an email because I don't have your number.
Yeah, you definitely want that number because you've got a few cases with Mr. Johnson.
I do.
Okay. He'll get that to you. Mr. O'Neill, obviously you and Mr. Johnson are going to need to connect, but he's asking all the right questions. He don't want to sit down with you until he's got a better sense of the state's angle on this case. I know you have had to work with several lawyers on this. They all share the same interest, which is trying to figure out the best outcome for you. I think you are a level-headed guy, and I think you understand that the best outcome in this case may not be the state dismisses the charges. It's probably going to be something a little more complicated than that for you. And Mr. Johnson will be able to look at what happened with your co-defendant, Mr. Palmer, to get a sense of where the case is heading. But it's also the situation that if you want to go to trial, that is your absolute right. Mr. Johnson just needs some time to figure out how best to counsel you on that. And if in the end you say, I don't want to work this out, I want a trial, he'll go to trial. You're not afraid of trial, but he may spend some time trying to convince you that trial may be the least good outcome for you. Not that there are great outcomes, but we'll see. So my thought, Mr. Johnson, since this has been fairly heavily litigated, is that we move this to a trial calendar, but we make that one that is early next year, which will give you a chance to connect with Mr. Hand and then talk with Mr. O'Neill. If it's going to work out pre-trial calendar, we can handle that at any point. But that at least will keep this on everyone's radar. It's an old case. It's not getting any newer. It is not old because anything Mr. Johnson did, and Mr. O'Neill was out of commission for a while when he went down into the state system, but it's mostly because it's bounced from too many lawyers, and we need to have it rest with Mr. Johnson. Does that work for you, Mr. Johnson?
That is fine, Your Honor. Definitely seek to have the matter resolved by the beginning of next year's trial.
Okay. Did you get Mr. Johnson's number?
I did, Your Honor. He just
Excellent. You are now officially connected telephonically. Mr. O'Neill, do you have any questions about anything?
Originally, I already had another paid attorney on my case already. I don't know why he's not here already.
So let me look up your case. Did you have Ken Shepard at one point?
Judge, I had Mark Gaffney.
Oh, right. Mr. Gaffney was on the case. I think he withdrew, but let me look it up.
I'm supposed to have Mr. Adam.
Let me look. So Mr. Johnson is your attorney of record, and he's filed a motion to that effect, and he replaced Mr. Mr. Webb. He replaced Mr. Webb, and Mr. Webb, boy, it's a line. He came in November of last year. Let's see if there's more. So who tried to withdraw from your case? In September of 2020, Derek Wright was your lawyer and he withdrew. That's right. I remember that. Then in August of last year, I signed an order allowing Mr. Gaffney to withdraw. So he was out. And that's it. So once Mr. Gaffney withdrew, and that is someone you or your family had paid, Mr. O'Neill, the only lawyers who have entered appearances would be Mr. Webb, who was with the Conflict Defender's Office, and then Mr. Cladis, and now Mr. Johnson. They're all with that same office. So you're free at any time to hire an attorney. But if you did hire one, that person has not filed an entry. And until he or she does that, they're not your lawyer, at least not for purposes of this case. They have to file that piece of paper. And if you've got a good lawyer, they'll know how to file an entry, but it's not here. So you may want to reach out to family to see what's going on, but your case is not going to slow down because your family's spinning its wheels trying to get that lawyer to file an entry. Mr. Johnson is the lawyer of record. He's going to get all the notices related to your case. He's getting discovery from his colleagues, and he'll be negotiating with Mr. Hand. And more importantly, he'll come to see you to talk about the case. If you choose to hire a lawyer, officially, that one needs to file an entry of appearance, okay?
Yes, sir.
All right, anything else? All right, you're free to go. Thank you, Mr. Johnson.
Oh, Your Honor, I believe I have one other matter on the calendar.
You do. I think you got a bond hearing, and we're working our way towards it.
Okay, no problem.
Mr. Hand, Mr. Walker is not available because Mr. Walker is deceased. Are you moving to null process 3 cases?
Judge, the state is moving to do that, and not presently. We've only been able to confirm that with the jail, that he is deceased. We have not received the actual death certificate yet. And so we did check as of October 6th with Vital Records, who have stated that they don't have the death certificate yet, but we're expecting them to get it within the next couple of weeks. And then we'll move to.
So there is no body to produce. He's not at the jail. He left the jail through the door you don't want to leave through. So what you're waiting on the
Actual death certificate to be filed.
Okay. Ms. Nelson, can we put Mr. Walker's 3 cases on an inquiry calendar for whatever the first one it can go on in November?
I sure can.
Thanks.
Thank you, Your Honor.
Hey, Your Honor, we would have no objection to that null process on behalf of Mr. Walker.
Yeah, there go 3 of your cases. Not quite yet, though. I understand the need for the paperwork, but hopefully before the inquiry calendar, the state will get that. If not, I'll make an inquiry with Vital Records to see what's going on. All right, that gets us to number 9. Mr. Tutman, is that you in 3 South?
Yes.
Great. Can you take a seat, please? There you are. Ms. Feely, this is your case. And Mr. Shapiro, are you the prosecutor?
I am, Judge.
Okay. I just got a note saying that this case is moving to a motions calendar. I'm happy to hear from either lawyer. What kind of motions are we hearing in Mr. Tutman's case?
Those were filed by the state, Your Honor. The state filed a 404-414 motion that will need to be heard. And so we've emailed Ms. Nelson to be placed on an available motions calendar.
Got it. Beyond that, is there anything from the state side that would prevent this case from going to a trial calendar?
Nothing from the state, Judge.
Okay. Ms. Feely, same question. Any motions? And if not, any reason other than you need a ruling as well on the 404-414 motion before we try the case?
No other outstanding motions or anticipated motions, Your Honor. I met with Mr. Tutman about the state's offer last week. So we're going to continue those discussions as well.
Okay. Then Mr. Tutman, we will get this set down as soon as we can for a hearing on the state's motion. You'll be here for that. Your lawyer will be here for that. We'll work through it. And we'll also get this case put on a trial calendar. Ms. Feely, Mr. Tutman's case is very old. Is it one that Mr. Franklin had asked to be put on judicial hold because of the pandemic?
It is, Your Honor.
Okay. All right. So Mr. Tutman, one reason why your case has aged a bit is that your previous lawyer, Mr. Franklin, filed a motion with me saying, we don't want to be that guinea pig case where we're first coming out of the pandemic and trying to figure out how a jury trial works, and basically asked me to put it on hold. And Ms. Feely is now comfortable with the way we're doing trials. In fact, starting in a couple of weeks, starting on Halloween, we're back to picking juries in the judge's courtroom. So it's as things are returning to how they were before, which means we need to get you on a trial calendar because you've been sitting in jail for a real long time with no resolution. That doesn't mean you can't resolve your case. It may be in the end that you and the state agree on something. You may choose to enter what we call a non-negotiated plea, where Ms. Feely asks for one outcome, the state asks for another one, and I decide what happens. That's my role. But the ultimate option, if you guys can't sort anything out, is to get a jury to decide whether the state can prove your guilt or not. I'm anxious to make that happen because you've been sitting around for far too long without an adjudication of some sort. So we'll get that motions hearing soon. We'll get your case added to a trial calendar and move forward that way. Do you have any questions, Mr. Tutman, about what's coming?
No, sir.
Okay, we appreciate you being here. You are free to, well, before you go, Mr. Shapiro, anything else on Mr. Tutman's case?
I don't believe so, Judge.
All right, Ms. Feely?
No, Your Honor. Mr. Tubman, I'll speak with you again soon.
All right.
All right, thank you all.
And Judge, that's my only case this afternoon. May I please be excused?
You may.
Thank you.
Sorry, bro.
All right, is it Chappell or Chappelle?
It's Chapel, sir.
All right, you're not up yet. You're welcome to wait right there. You're in the right space. We've got a few cases ahead of yours, okay?
Thank you, sir.
Mr. Robinson, can you hear me?
Yes, Your Honor.
Boy, that is the darkest booth ever. I have to, is the light out in there, or does it look dark to you, or it looks normal?
I know lighting.
Okay, that's a little better. Thank you. So I've got some good news for you. We have begun to get lawyers to get back involved with criminal cases, and we are on the cusp of getting someone appointed to represent you. I can't give you a name quite yet, but I suspect that in the next couple of weeks, a lawyer will come out to visit you to talk about your case and what ought to happen with it. And if what ought to happen with it is it's a trial, obviously that lawyer is going to need to learn. There's a whole lot of moving parts in this case, but the critical point is there'll be an advocate for you who can let you know what's going on and with whom you can begin to confer about what you want to have go on with your case. Okay?
Yes, Your Honor.
Now, as before, if your family chooses to hire someone like you have before, you're free to do that. But it sounds like the money you had was spent on the lawyer who withdrew, which doesn't help you out a whole lot. But we will get a new lawyer. And when I say new, that doesn't mean a lawyer who's never practiced law before. It just means new to you, assigned to your case in the next couple of weeks. And then that person will work with Mr. Hiles, who's on the screen here, as well as with you to figure out how we can move this forward. Okay?
Yes, Your Honor.
All right, Mr. Hiles, anything you want to add? I just owed Mr. Robinson this conversation, and for the first time in a while, I'm able to share good news with him that it's not I'm not sure if we can, but it is literally in the next couple of weeks. Each of us who have submitted this wasn't a C3 case, but it is now for Mr. Robinson, we're getting lawyers appointed.
As soon as there is someone appointed, I'll make sure they get discovery promptly. That's really all I have to add.
Good. No, and I appreciate you doing that. I think that'll be cleaner than trying to get it from Mr. Robinson, trying to get it from Ms. Taylor. I think
we're not doing that.
No, agreed. We'll get it directly from you. Okay. Let me make one note. All right, Mr. Robinson, do you have any questions about what we just talked about?
No, Your Honor.
Okay. Well, look for that lawyer to pay you a visit in the next couple of weeks, okay?
Yes, Your Honor.
All right, you're free to go. So, Mr. Pritchett, I won't interrupt your biblical readings. We actually just needed to talk to Mr. Robinson today. You've made your desires very clear, but since they put you in one of the cells, I didn't want to miss the opportunity to see how you were doing and let you get back to your reading. Mr. Hiles, anything in Mr. Pritchett's case?
No, Your Honor.
Okay. All right, Mr. Pritchett, you are free to go. You're free to stay. That gets us to now, Mr. Chappelle. All right. All right. Who is here? Tell me again, Chappelle or Chapel?
Chapel.
Chapel. Okay. Oh, we got people here in court. Mr. Chapel, you have a large legal team here in court. And we're going to get all this on the record. We've got a probation revocation hearing. Let me get the defense counsel table added to the spotlight so you can see one of your representatives right there. And let me get my paperwork ready. All right, let's get on the record. This is positions 12 through 14, all cases involving Mr. Chapel. And I have warrants that I signed alleging violations of probation in each of the three cases. Can we have the appearance or appearances for Mr. Chapel, please?
Just briefly, Your Honor, if I may. I am actually not here on behalf of Mr. Chapel. I am here on behalf of the late attorney Michael Hauptman. He recently passed about a month ago.
I read.
We got notice in the mail, and I just wanted to ensure that somebody appeared before the court just in case. But it does seem as if it is in good hands. So my name is Clarence Hollins, and that's pretty much the only business I have before the court.
Well, I appreciate you being that thorough. It does look like Mr. Hauptman had the two older cases, and then Mr. Adams was listed as counsel of record for they're all old cases, but the least old. But on my calendar, it has Mr. Adams replacing Mr. Hauptman in the 08 case and the slightly less old, the slightly older 11 SC case.
Excuse me. We did not have any contact information for anybody as Attorney Hauptman's computer was locked, and we're still trying to get into it as one of those 90s computers.
with big 5 1/4-inch discs. Yeah.
So it's a little bit more difficult, but I, again, just doing due diligence to ensure that the court was aware. We are already making a notice for the Georgia bar as soon as it's
Okay. Well, thank you for doing that, following up on his behalf, and my sentiments to friends and family.
Thank you, Judge.
You bet. You may. Thank you so much. Good afternoon, Mr. Adams.
Yes, good afternoon. Good afternoon. I do represent Mr. Chapel in all of his pending cases, including an unindicted case that is going to be the subject of
what brings us together.
That is correct, sir.
Okay. Yes. Well, let's get on the record then. This is 08 SC 67957, 11 SC 100815, and 11 SC 102392. And in August of last year, I signed 3 warrants, one in each of those cases, alleging that Mr. Chapel had violated his probation in each of the 3 cases because in July of last year, Mr. Chapel was allegedly back in the game and had committed the offenses of trafficking in methamphetamine, heroin, and other illegal drugs here in Fulton County. I know we had at least one hearing on this, not a substantive hearing, a procedural one. And I'm going to let Mr. Adams get us up to speed because he's the constant in this. Mr. Hand handling things for the state, but wasn't the prosecutor who was here for the at least one earlier, if not two, appearances that Mr. Chappell had in connection with these revocation proceedings. So, Mr. Adams, why don't you orient us as to what has happened, and then Mr. Hand can let us know what's going to happen today.
Yes, Judge, thank you. All right, so I was retained by Mr. Chappell and represent him on the new case, the unindicted case. He was arrested on July 31st of 2021. He's been in continuous custody since that period of time.
And that was arrest here in Fulton County.
That was a Fulton County arrest.
By what agency?
I believe it would have been APD, although the investigation was conducted by a joint task force involving GBI primarily. There was some federal agents involved and the Atlanta Police Department, as I understand it.
Do you have a CP number for that?
I have it, Judge, if you need it.
I'll take it from anyone.
Pre-trial, Your Honor, if you need it.
I just need it from one person.
21.
Mr. Hand, why don't you do it?
Yes, Judge, 21 CP 201 810.
810. Great. Thank you. Back to you, Mr. Adams.
Yes, sir. At the time of his arrest, Mr. Chappell was currently on probation before this court, in the numbers already listed by the court. He was on probation, placed on probation in 2012, and his probation runs in 2026 by my calculation.
Okay, and I'll get the official numbers from probation in a minute, but that's helpful. So it's not that there are 30 years remaining. There are 3 years, maybe 4 remaining.
3 years, 9 months by my count,
Okay.
approximately.
Okay.
But again, just procedurally, he was, and this kind of brings us to what happened last time. He was also on probation in Henry County and also on probation in Gwinnett County. Now, it bears saying that the Henry County case and the Fulton County case are related. Just very, very briefly, essentially there was an investigation in Henry County. He was arrested in Henry County. Pursuant to that arrest, they did a search warrant in Fulton at his residence. There were items found there, and those became the sum and substance of the charges in Fulton.
The new charges in Fulton?
No, the old
ones. Okay, got it. So when in 2012, Mr. Chappell was sentenced for the 3 Fulton cases, he was either already under sentence or was about to be under sentence in Henry for this connected, related conduct.
That is correct.
Okay.
That's correct. So that's the relationship between Henry and Fulton. But nonetheless, at the time of his arrest last year, he had the Fulton County probation, he had the Henry County probation, and he had a separate Gwinnett County probation.
Was the Gwinnett case a drug case also?
It was a drug case. It was unrelated to the Fulton and Henry cases.
Other than that, it's the same client?
Yes,
Okay.
exactly. Same client, same type of offense.
Okay.
All right. Now, so he gets arrested in July. He was given a bond. I believe the bond initially, before my involvement, was something in the area of $750,000.
That's a big bond.
It is indeed a big bond. I would contend unreasonable, but nonetheless.
But he made it.
At some point after my entry into the case, I filed a request for a reduction in bond. His bond was subsequently reduced to, I believe, $150,000. If I can look at the order. All right. So at that point, he was in a position where he could make bond, except that he still had to hold on him, and the case was still unindicted. The new case was unindicted.
Oh, so he didn't, I'm looking at the orders now.
Yes.
Mr. Chappell did not post $750,000. Judge Borski in October of last year reduced it to 150, and he has posted that, but all that got him was a ticket to Henry or Gwinnett.
Right. As a matter of fact, we knew that he could not go anywhere by posting that bond. We filed a motion for a probation bond in front of Your Honor.
Mm-hmm.
We appeared in front of Your Honor, and the court's position at that time was you did not want to address the issue of a probation bond until we had some clarity or until we handled Henry County and Gwinnett County.
Right.
All right.
If Henry was going to revoke for 3 years, don't need to worry about bond.
Right.
Okay.
So what we did at that point, bond was posted. He went to Gwinnett. He went to Gwinnett County, and Scott Drake represented him in the Gwinnett County probation revocation, and he got a $10,000 probation bond in Gwinnett County. Their position is, let's see what happens in the case that's in Fulton.
Okay.
So they gave him a bond. He hasn't posted that, but he has the bond.
Okay,
He came
so
back-
Gwinnett has not revoked. They're waiting to see what happens here.
That's correct.
Okay, the dominoes will fall.
He came back to Fulton, and we attempted at that point and attempted a number of times to get him to Henry, pursuant to your request that let's get those others handled. His family retained counsel in Henry County. He was set on a calendar in Henry County at least 2 times. Henry would not transport him. They said, well, you know, we're still coming out of COVID, we're scant on resources. They would not bring him over, nor would they set a virtual hearing. He's represented by Michael Brill in Henry County.
Oh, Mr. Brill's on the call.
Okay.
Yes, Your Honor, I am here.
Okay.
And so he had been set for hearings previously, either canceled or not fully verified. He never appeared in Henry, although at this point, he is set for a hearing on November the 1st.
But we don't know that he could get there or that they would do it virtually.
Mr. Brill is probably going to be in a better position to answer that question. I just know that that's the date that is set at this point.
Okay, Mr. Brill, what do you have to say about the likelihood, assuming Mr. Chappell remains in custody in Fulton, as in he doesn't get a bond today, is he going to get transported to Henry, or Henry will do it virtually, or none of the above?
So, Your Honor, the first issue about the court dates were, one, the probation office down here didn't have an incident report from Fulton County, so they hadn't filed a petition, even though he had been arrested on probation warrant. So that was the first objection for the clerk's office, putting him on any calendar. We submitted a proposed order. We submitted an order for the judge to sign as a production order to get him down here, I think as far back as June or July. And the clerk's office and the judge's office took the position that if he's not in Henry County, then we're not going to put him on a calendar for VOP for the reasons that Mr. Adams so succinctly described. The Henry County Jail, not to the extent the Fulton County Jail is, but is at capacity and slightly overcrowded. Having been in both jails, I understand that that's not an excuse for anything to move these cases along. I think it would actually move this case along, but I don't make the decisions. I just ask and ask and ask and try to get the judges to move these cases forward. Your Honor, it is confirmed that we are on a calendar for November the 1st. We were supposed to be on a calendar earlier this month, but a calendar on October the 20th had been canceled, so everything got moved around. That was my explanation. Probation has filed the petition to revoke his probation here. We have the incident report, and we're planning to move forward with that. We are confirmed to be on the calendar for November the 1st. So it is my understanding, it is my sincere belief that he will be transported to Henry County for that hearing. I provided a production order to judges' chambers to get that, to complete that, so we can get him down here for him.
Got it.
And so, Judge, if I may jump back in,
please.
And so I found, not having any real sense of what Henry or when Henry was going to do something, and our ability or inability to comply with the court's request, I filed another motion for probation bond, kind of setting those things out and asking, and that's why I thought we were here today. I think that's what's on the calendar, although I was advised in speaking to Mr. Hand that the state intended to actually have the probation revocation hearing as opposed to simply a motion for bond.
Right.
But we've had some conversations since then.
Okay.
Mr. Hand and I, we have what I believe is a joint proposal for the court, subject, of course, as always, to the court's acceptance and feelings on that particular resolution.
Okay.
Mr. Chappell's been in for about 14 months. No, 1 year, July, August, September, October. 1 year and 3 months. The case is not indicted. The new case is not indicted yet. I don't have any idea when it's going to be indicted. I don't know if they're crime labs they're waiting on. I don't know what it is. We will have to deal with that case at some point. Right? And they're serious charges. They're not charges. They're charges that carry mandatory minimums. They're going to be some serious penalties.
They are, and if there's any substance behind the charges, presumably a judge is going to look at the criminal history and say, we've tried probation, and look what happens when you get back out.
Right. I will tell you that I've had conversations and meetings, as has Mr. Chappell, with individuals who are involved in the investigation of the case. It involves other individuals, larger individuals in some other jurisdictions, federal jurisdictions. And I am hopeful that those discussions and possible dealings might aid in some resolution of the case down the road.
Sure.
Nothing's been promised. We don't have anything yet, but that's where I think we're heading. And speaking to Mr. Hand, if the court is inclined to accept this recommendation, our request would be that Mr. Chappell stipulate, for purpose of this hearing, to the violation of probation, and ask that the court sentence him on a revocation to 18 months. He served 12 plus 3 is.
He's at about 14 now, a little more than 14.
To 18 months in custody, and then reinstate him to probation, and then let us deal with. And he can always be. Well, no, he would have been revoked already. So we'll deal with the other case as before.
Right. I mean, Henry's going to do what Henry does, and it sounds like Gwinnett, so he will still ride that circuit. And once we resolve this with whatever we resolve it with, he ought to be able to move more readily to Henry.
Yes, sir.
Let me get a little more information. Ms. Tucson, how are you doing today?
Good afternoon. I'm good. How about yourself?
I'm okay. How much time remains on Mr. Chappell's cases?
Okay, so what I have here are 5. The 3 in Fulton, 08 SC 67 957, 3 years, 7 months, 12 days.
Okay.
11 SC 100815, 3 years, 7 months, and 9 days. The dates are pretty close. And on 11 SC 102392, 3 years, 8 months, and 11 days. And if you need the time for the Gwinnett and Henry, just let me know.
I am curious, you don't need to give me the case numbers, but are either of those cases longer terms of probation, or is the longest this 3 years and 8 months?
No, the one in Gwinnett is the longest. It expires February 7th, 2028. So he has 5 years, 3 months, and 26 days on Gwinnett.
Got
and
it.
Henry is 2026 as well as the other 3.
Okay. Understood. So Mr. Hand, let me hear from you, please.
Yes, Your Honor. Thank you. Your Honor, I spoke to Mr. Adams, and he caught me up to speed on some of the stuff that occurred at the last hearing. Mostly that you wanted to see what happened in Henry County and before moving forward in Gwinnett. And at first the state's inkling was to let that happen, but then I heard that there have been these hearings that have been canceled and then put back on. So to not hold this up, if Your Honor, if the court wants to proceed, then we discuss 18 months being the revocation amount and then reinstating to probation. The state feels that is reasonable given the history here. There are 3 felonies, Your Honor, cases that are on the calendar. They're all the same charges, or they have one same charge in common, that being the trafficking and meth charge and other drugs as well. That's really all we have from the state, Judge.
All right. So no one's committed to anything. If Mr. Chappell wants to go forward with a stipulation to the charges, basically stipulating that he was arrested. That's what the stipulation is. But because of the nature of the charges, I am comfortable hearing nothing more about the charges, revoking 2 years, giving Mr. Chappell credit for all the time he's been in. So from July 31st, 2021, I would close out positions 12 and 13, and then I would reinstate the balance on position 14. So he'd be on probation just for 11 SC 102392. That one would keep moving forward as the Fulton piece. Then Mr. Chappell would need to go to Henry and Gwinnett to figure out what they would do in connection with the same basis, this being arrested for but unindicted for the conduct in Fulton County. That is a little different than what Mr. Adams negotiated on Mr. Chappell's behalf. I am fine, and I think we can do this if you, Mr. Adams, can connect to this Zoom from your phone. You and Mr. Chappell could have a private conversation about that. I can give you the Zoom link if you don't have it. And then you could just be in the jury room, talk with him while he's in a breakout room to see if he's comfortable with that. And if he's not, I respect his disagreement and we can go forward with a revocation hearing, because it sounds like you've got someone from law enforcement here that you believe could establish by a preponderance, which is a low standard, but the standard for a probation revocation hearing. And it could be after I hear more about the situation, I think that 2 years is too much. It could be that I think it's insufficient in light of what Mr. Chappell had done in the past by way of his guilty pleas in the 3 Fulton cases, the Henry case, and the Gwinnett case.
Judge, let me ask you a question if you don't mind.
Please.
And I do need to speak to Mr. Chappell to see if that's something that he's willing to do. If we end up in a position where the court imposes a revocation for 2 years, would the court be inclined to state that in terms of 24 months as opposed to 2 years? I don't know and I suspect you know why I'm asking that. So that any time served would be in the Fulton County Jail as opposed to Jackson or somewhere else. I don't know that they're going to do that. They may still look at it because it comes from a Superior Court sentence.
Right. So no, because 1, I'm thinking of 2 years rather than 24 months. 2, this isn't necessarily Mr. Chappell's problem, but the jail is very full and I don't view it as a housing place for a sentence. It's a housing place for people awaiting indictment or trial. And unfortunately for your client, he's been awaiting indictment. What would have been grand would have been an indictment in a timely manner. He's not alone in that situation. And it's frustrating. I know the district attorney's office is beginning to work at that, but I think you are wise to try to move this because the nature of Mr. Chappell's charges, while serious, fall behind in the scheme, as I understand it, of how they're going about prioritizing what gets grand jury attention. Okay.
Zoom link, please.
Yeah. So the meeting ID is 929-1926-7520. And then the passcode is 212.
264-212 is the passcode.
Yes, sir.
Meeting link is 929-1926-7520.
Correct.
You'll understand, man, as the
You can go, the jury room is right through this door. Officer Brooks, I appreciate your patience on this. I assume Officer Brooks is here for Mr. Chappell.
Yeah.
So if you don't mind sitting tight a little while longer. So yeah, the jury room is right through that door. And I'll know when you get on because there'll be, as long as you identify it as Adams or something, and then I can drop you and Mr. Chappell into a breakout room. Okay. Mr. Chappell, once Mr. Adams has dialed in on his private line, I will move you and Mr. Adams into a breakout room. That's a private space. I can't see you. I can't hear you. The prosecutor can't see or hear you. So the two of you will be able to speak in confidence about what I've explained I'm willing to do in this situation. And then Mr. Adams will physically reappear. That'll be the way I know you guys are done talking. And I'll figure out how to pull you out of the breakout room back into this setting. Okay?
Yes, sir.
All right.
Yes, sir.
So in a moment, once Mr. Adams has logged in, we'll turn to Mr. Pittman, who is in. Let me
Jeez.
on. You're not muted. Okay. Mr. Pittman is in 6 South Booth 3. And you guys are being patient. After Mr. Pittman is Mr. Ransom. And then last but not least is Mr. Lloyd. So you guys sit tight. We haven't forgotten about you. Hey, Mr. Pittman, can you hear me?
Yes, sir.
Great. We're not going to start quite yet. We need to get Mr. Chappell in that breakout room, but as soon as he's in there, we're going to have a bond hearing in your case, all right?
Sure.
Mr. Johnson, I believe this is your client now. You ready to go once we get Mr. Chappell where he needs to go?
Yes, Your Honor.
Great. There he is. All right, Mr. Adams, I'm going to move you and Mr. Chappell into the breakout room. Let's hold your breath. See if I can do this.
Sir.
Adams and 3 South Booth 1. He's gone. Excellent. It worked. Look at that. Holy moly. Let's get Mr. Johnson on here. Oops, Mr. Johnson, you need to start your video and we can add you to the spotlight. There he is. Excellent. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Great. Thank you. Let me get this up in one other place. All right, hold on one second. Whoops. Hey, I'm in the breakout room because you asked for help. Should I get out of the breakout room? I think he's coming back. There you are. Okay, I'll see what I can do. Don't talk yet.
It's like you're still muted.
Yeah. Oh, don't talk yet. Please don't talk yet.
Okay. Can you hear me now?
Nope. Just wait, Mr. Adams. Mr. Adams, hold on, okay?
Yes, sir.
I'll give it a try in just a second. All right.
I'm unmuted now.
Okay, don't talk yet. I got to get out of this room. Everyone can hear you until I get out of your breakout room, okay?
Yes, sir.
All right. All right, I'm leaving now. You guys should be good. Ah, phew. Okay. Yep. You're private and we're back in business here. Okay. Why is it? There we go. All right. There. Okay. Fix the reverb. Mr. Johnson, can you hear me?
Yes, Your Honor.
Great. Sorry about the delay. Let's get going with the bond hearing in Mr. Pittman's case. This is 21 SC 178773, State versus Pittman. We've got Mr. Hiles for the state. Mr. Johnson is Mr. Pittman's attorney. And I am just looking at the status of the case. We've just had some attorney transition, and that's it. So we ought to be talking about bond. Why don't you get us started, Mr. Johnson, please?
Yes, Your Honor. Before the court today is Mr. Leandre Pittman, an 18-year-old lifetime Atlanta resident with significant ties to the community. He stands before the court in indictment number 21 SC 178773, a 15-count indictment with a variety of charges, Your Honor. We do believe that my client is a significant candidate for bond. He has significant ties to the community. As it relates to this particular case, we do not believe that there's a threat to him to intimidate or influence any witnesses in this particular case or frustrate the administration of justice. I await as you know, I've just been appointed to this case, so I would defer to the pretrial department with regards to my client's criminal history in this particular matter. Your Honor, would just like to point out, as far as some facts as it relates to this case involves a carjacking of an individual that took place in Northwest Atlanta. Based on my review of the evidence in this particular matter, my client is tied into this matter based on some cell phone information and a potential fingerprint. That's it. So there is no direct evidence placing him at the scene of the crime itself, basically only allegedly in the vicinity of the crime. So taking those things into consideration, Your Honor, even though these are some very serious charges, actually, all of the charges all relate from the murder of the individual in this particular case. So the number of the gang charges is based on his alleged association with other individuals who allegedly have committed some crimes in the past. The crime in which mostly being car theft in this particular matter, Your Honor. Now, as I said before, I would defer to the pretrial with regards to my client's criminal history on those particular matters. But as it relates to this particular situation, Your Honor, there is not a significant piece of evidence tying my client into this case. We do not believe that there's a witness or a victim in this case that my client will be, that there's a threat that he would do anything to. He has not been identified by any witnesses in this case. It is merely the cell phone information that the state is using, and I believe one fingerprint found on the inside of a vehicle. So for those following reasons, Your Honor, we ask for a bond, a reasonable bond in this case, with whatever conditions and limitations that the court will be inclined to place on my client to feel comfortable with regards to his release. Thank you.
Okay, thank you. Tell me a little bit more. I know you're new to the case, and so we may need to get some of it from Mr. Pittman, but you asserted that Mr. Pittman has deep ties to the community. Is that family? Is that kids? What is it, other than that he was born in Atlanta, that you say ties him to the community?
Family, Your Honor. I believe if he was granted release in this case, he would be living at 4060 Janice Drive, East Point, Georgia, which is his mother's residence, Your Honor.
Okay. All right, Mr. Pittman, is that where you were living before you got arrested, or were you living somewhere else?
That's where I was living before I was arrested.
Okay. All right, Mr. Hiles, what are your thoughts about bond for Mr. Pittman?
Your Honor, the defendant has an open case in Clayton County from 11/26 of 2020 for financial transaction card fraud and possession of Schedule 2. He also had, at the time of his arrest, he had open warrants for participation in street gang activity, as well as theft by receiving. However, those were lumped in with this indictment, and the incident date for those warrants was October 7th of 2020, just before this alleged murder we're here for today. It was given a CP number, and I realized recently that it needed to be transferred to juvenile court because he was 16 at the time of those warrants. from October 7th of 2020 out of Fulton County. And then he has this arrest, an indictment that he's charged with. He also has an adjudication of delinquency under 20 DL 00811 from June 25th of the incident day was June 25th of 2020. Your Honor, the state does feel that this is a very strong case. Your Honor, cell phone records place both the defendant, Mr. Pittman, and his co-defendant, Antonio Sanders, at a location in Gwinnett County just prior to this homicide. At that location, individuals were interrupted attempting to break into cars, and 3 individuals from that scene opened fire on a hotel room in Gwinnett County. So Mr. Pittman's cell phone records place him there. His defendant, Antonio Sanders' cell phone records place him there. And then those cell phone records simultaneously track from Gwinnett County to Fulton County, where in the early hours of October 20th, 2020, the victim in this case, Mr. Lawrence Denny, was dropping off items at the Goodwill on his way to work just before 4 a.m. This Goodwill was at the intersection of DeForest Ferry and Collier. Cell phone records placed Mr. Sanders as well as Mr. Pittman at that scene, and gunfire was exchanged as the victim's car was stolen. Shell casings.
When you say gunfire was exchanged, is it your understanding that Mr. Denny was firing at whoever was taking his car?
Yeah, he was fired upon and then drew his weapon and began firing back.
Okay.
It's on video.
Okay.
But the shell casings recovered at the scene in Atlanta matched one of the guns of shell casings recovered in Gwinnett County in a very short time span. Mr. Denny's car was taken from the scene and Mr. Sanders and Mr. Pittman's phones tracked together on phone calls in the same direction to the area where the car was ultimately recovered at an apartment complex called Camelot. The Instagram records of Mr. Pittman show a pattern along with other gang members in this crew of stealing cars and using those cars to steal others and procure weapons. The exact cars that were used in the two incidents on this date were discussed the day of by Mr. Pittman with another individual as being the 2 cars they had left at Camelot. He then directly references just after the murder on October 20th that the Cadillac had been destroyed, essentially. And then when it was recovered, it was riddled with bullet holes. And he also sent a direct message to a gang member saying that old boy died last night, which the state is saying is in reference to this incident. I also want to point out, Your Honor, that in these communications, the defendant was actually talking to his mom over Instagram. She identified himself, and through those conversations, his mother was indicating how disappointed she was in him and Mr. Pittman telling his friends that they could continue to stay at his house and at her house, even when she was not there, and how that she intended to move and that there'd be no more friends allowed. But I say that because I don't feel like returning to that environment would be a good spot for him, especially it seems like from the records that his mother couldn't control his behavior anyways. Your Honor, there is strong gaming evidence. I believe this crew referred to themselves as 5275 young gang slime crew. And so I think, I don't know what all discovery Mr. Johnson has. I don't know if I'm referencing things that he hasn't seen yet because it is voluminous. But the state feels that he is an absolute threat to reoffend because in that, especially in the log of his Instagram records, he discusses many cars that were stolen and actually recovered by City of South Fulton Police in that Camelot apartment complex. The ties, there's 3 stolen cars involved in this. And additionally, the day of the homicide, Mr. Pittman was searching urgently for somebody to trade weapons with him just hours after the homicide, presumably because one had just been used in a homicide. Your Honor, the state feels it's a strong case. The defendant's a strong threat to reoffend. And just being the mere nature of being in a gang, it adds to that threat to reoffend. That he's a dangerous to society, and he's also a threat to flee based on the severity of the charges and the evidence against him. So for those reasons, the state would ask that you deny Mr. Pittman's bond at this time.
Mr. Johnson had referred to a fingerprint. Do you have any information about that?
Yes, Your Honor. There was a fingerprint recovered in one of the cars that was used associated with both the shooting in South Carolina. I mean, not South Carolina, in Gwinnett County. Sorry, I'm thinking of another case in Gwinnett County, as well as the stolen Kia that was believed to have been used in the homicide at Collier Force. Yeah, and so that's been turned over. I know that's definitely in there, and it should be noted that the recovery of these cars, including the victim's stolen Cadillac, was within 2 hours of the incident actually happening. And additionally, as those phones tracked together, Antonio Sanders, his co-defendant, actually connected his phone to the computer system of the Cadillac, so we can see that. We have that information as well.
Okay. I appreciate you sharing all that. Let me hear from pretrial services, and then I'll circle back with Mr. Johnson for the final word. So, Ms. Gordon, I don't know what visibility, I don't recall, you or one of your colleagues have maybe explained this to me before, what visibility you have into juvenile records, but Adam, why don't you share with me what you have about Mr. Pittman?
Your Honor, the GCIC indicates the defendant has 3 cycles beginning in 2020. Last arrest was November 26th of 2020 out of Clayton County for possession of marijuana less than an ounce, financial transaction, card fraud, and possession of a Schedule II controlled substance. That case is open. No felony convictions listed. On occasion, we do, when we run the GCIC, if there's sometimes a juvenile record would be attached. In this case, no juvenile record was attached. Nothing further to add, Your Honor.
Thank you, ma'am. Appreciate it. All right. Mr. Johnson, anything you want to add?
Yes, Your Honor. Based on the recitation of my client's criminal history, given that his stated his last arrest was November 26th of 2020 and he has no felony convictions, my client was arrested on November 26th of 2020, at which time that's the time he was served with the warrant for this particular case, Your Honor. So prior to his being arrested for this particular case, he had no felony convictions or anything else like that. So therefore, any of the state's assertions that my client is involved in a gang that is doing criminal activity around the city has not resulted in any prosecutions or convictions against my client at the time. So that is nothing but a presumption by the state that they would have to prove in further proceedings if they have any other than this one. As it relates to the vehicle and the fingerprint that was recovered in this case, Your Honor, I don't want to say that the state misspoke, however, but the vehicle that my client's fingerprint was found in was not at the scene of the location in this particular situation. The car was stolen, then taken to a second location, and that is where the car in which my client, the fingerprint in which my client was found was seen. So it was not at the actual location of the murder itself, Your Honor. So that's one thing. Also, Your Honor, as I stated before, my client is 17 years old. He's about to be, 18 years old. He's about to be 19 at the end of this month, Your Honor. My client does not have the financial resources to flee the jurisdiction of the state. My client does not have a job. He has been in jail since 2020. So therefore, he does not have the resources to flee. As it relates to his mother's home, Your Honor, being that's the location where he lived prior to this incident. The state can believe that his mother does not have the ability to curtail his actions. The court has the ability to do so by placing him on an ankle monitor or curfew and also stay away provisions. We would have to say prior to his arrest in this case, Your Honor, my client was not risking incarceration by being around his friends. So therefore, if he was released with the condition to stay away from these individuals, that is the added impetus for these individuals not to come to his mother's house, which would ensure that these individuals are not around and help his mother, who may need the assistance to secure these individuals from not being around the location. So that is something that can be done by the conditions of the court and does not require continued incarceration on my client's behalf. As stated before, Your Honor, my client has never been convicted of any crime involving the theft of automobiles in the state of Georgia. These are just allegations at the present time. And as stated before, my client is not identified by any witness by being at the scene of the crime. It is merely his cell phone that the state can say is present. They're proceeding under the presumption that his cell phone was on his person at that particular time, but that may not have been the case, and that can come out later on at trial, Your Honor. That is not a true presumption to state that he was present at the time of the crime. And with regards to that, with regards to cell phone information, Your Honor, you know that only gives an area, saying that these individuals are in the same area. It does not mean that they're standing right next to each other or within 5 to 10 feet of one another. So taking all of these things, Your Honor, given that my client does not have a significant criminal history whatsoever, his last arrest is still a pending case for which he has not been able to address because of his incarceration as it relates to this matter, Your Honor. So we still, on those situations, Your Honor, we would ask for a reasonable bond to be set in this case with whatever conditions the court will be inclined to do to secure his presence in court, as well as him staying away from any other parties or locations that the court will be inclined to say so. Thank you.
You're welcome. Mr. Hiles, the victim's family, Mr. Denny's family, do they have anything they want to add to the mix? They have a right to be heard here. I forgot to ask you when you were presenting.
So I spoke. He was an elderly man. He was unmarried. His only other family is the surviving spouse of his brother. I spoke with her. She said she opposed bond, and she just wished that our office, proceed as in the pursuit of justice as we see fit. Were her words. And not to add any more facts, I think I did misspeak, Your Honor. Mr. Johnson was right. Where the fingerprint was recovered of Mr. Pittman, as soon as the Cadillac was stolen, it was taken to another incident location where a temporary tag was stolen off of a car and then placed onto the Cadillac. That is where Mr. Pittman's fingerprint was recovered.
From the car whose temporary tag was taken?
I'll have to pull that back up. I think it was from the car that arrived, shortly thereafter to that scene.
Okay. Other question, you mentioned that Mr. Pittman had a finding of delinquency in June of 2020. I don't think you said for what. Do you know for what?
It was, so the incident date was in June 25th, 2020. The disposition was August 26th of 2022. It was for theft by receiving and for obstruction of law enforcement officer.
Theft by receiving a car, a computer, a lawnmower?
Your Honor, it was transferred. I'm sorry. It was adjudicated delinquent. I'm not sure which county. It was transferred on November 22nd of 2020. And then the case was closed out on August 26th of 2022.
Okay.
But I don't have that incident report in front of me right now.
Okay, not critical, just curious what you knew. All right, Mr. Pittman, at this time, I am not going to set a bond in your case. I don't feel that I could set a bond that would ensure, number one, your reappearance in court. I appreciate Mr. Johnson's observations about conditions I could impose at your house and what Mr. Hiles shared about your mother saying no more of your friends over at her house. But I don't think returning to that environment is the right plan for you. I'm also not convinced that I could set a bond that would have sufficient conditions to keep you out of trouble while you were out on bond. So for now, I'm going to keep you in a no bond status. But if for some reason, other than your lawyer says I need more time, which he may, your case stalls. In other words, if the state's not ready, they say we don't have this, our witness isn't available. I invite Mr. Johnson to revisit this question of bond. My goal is to get you and Mr. Sanders into court for a trial or some other disposition of your case soon. And I believe the best way to ensure that you are there and you are there without new charges is to keep you where you are right now. Mr. Johnson, you knew a whole lot about this case already, which is great. Doesn't surprise me that you've invested in it. Is it your sense that the file that you have inherited from Mr. Cladis is pretty complete? Or does Mr. Hiles need to make sure that you've got everything?
Your Honor, I have 2 zip drives full of information. I think that everything I have is pretty close to the charges that he has, the charges that are listed on the indictment. So I don't think that there's anything that I don't have at the present time. But if once I finish my review of it, if there's something that comes to mind, I'll definitely reach out to the state.
Okay.
Your Honor, I was just going to say, I'm going to reach out to Mr. Johnson if he's available right after this, because I think there's a flurry of things that were turned over to Mr. Granums and Mr. Cladis rather late, just in this process. And so I want to make sure that that they have the whole file.
Sure. I know in July of this year, there was another jump drive or something that got produced. Well, it looks like it was some paper. But anyway, I appreciate you doing that to make sure that you're flagging for Mr. Johnson the things that came most recently. I think this case is ready to be put on a trial calendar. That would be early next year. It wouldn't be this year. Any reason, Mr. Johnson, we shouldn't do that?
No, Your Honor, I don't see why not.
Okay, Mr. Hiles?
No, I don't see why not. There's been a third that was previously unidentified person that I think I'm going to talk to Mr. Johnson today, but I think I was actually identified him today. But that, given the procedure of this case and how far we are into it, I don't think it would be appropriate, even if I'm going to charge him, to postpone their trials any longer.
Okay, I agree. It may be that there's a third person who comes along, but his or her arrival on the scene ought not to mean that Mr. Pittman waits longer for a day in court.
No, I agree. And that's why I said there could be some additional information coming, but I don't think it would change. It'd be anything they couldn't process before the first of the year. and I
Okay.
don't think we pulled them up.
Great. Mr.
We're holding our breath for an exoneration.
There's always that. There's always that development. Mr. Pittman, Mr. Johnson will come see you soon to talk more about your case. I want to make sure we get you a trial date soon because it sounds like, given how serious these charges are, that's how this one's going to shake out. But if there is a way to resolve it short of trial, I'm sure Mr. Johnson will let my staff know and we'll get you here before then. Okay.
Sir.
All right. Thank you. You're free to go. Thank you, Mr. Johnson.
Thank you, Your Honor. May I be excused?
You may.
I'll be in touch with the house.
Yeah, I'll call you shortly. Your Honor, may I please be excused?
Yes, you may.
Thank you.
All right, Mr. Adams, let me get Mr. Chappell back up here. I think I can, he may be stuck in the breakout room. I may have to remove him, but I can do that. 3 South. There he is. Mr. Chappell is right there. Mr. Adams, we will add you to the spotlight. So Ms. Rivers, if you are able, we're going to pivot back to Mr. Chappell's 3 cases. Mr. Adams asked to have some time to speak privately with Mr. Chappell about how Mr. Chappell might want to move forward with his revocation on the 3 matters before me. Mr. Adams, did you and Mr. Chappell have enough time to speak?
Yes, sir, we did.
And what is the plan from the defense side?
There will not be a need for a hearing.
Okay.
Mr. Chappell is willing to stipulate to the violation for purposes of this hearing, not for purposes of admission of guilt on the underlying offense. We understand what the court's recommendation or the court's sentence is likely to be. And so we'd simply like to be heard as to whether the court on sentencing would consider one of 2 alternatives to straight incarceration in prison. A 2-year revocation, given credit for the 1 year and 3 months that he's already served, we'll send him either to Jackson and then some other location or some other location for the remainder of that, some portion or all of the remainder of that revocation. Mr. Chappell is 50 years of age.
50?
50.
Okay.
He's 50 years of age. He was born in Tennessee, but grew up here in the Atlanta area. Went to high school in Gwinnett. Went to Georgia Tech, received a degree from Georgia Tech after his incarceration. Was gainfully employed, owned a web design business prior to his incarceration. Is unmarried, but has a daughter who's currently in court. His family, his daughter, see right over there. You see her on the far right, your far left.
She just waved.
His sister, Mr. Chappell's sister, who's seated right next to him. He does have family here that lives in Snellville, his mother and his father. So he has some pretty strong ties to the community. I would show you, I guess I could just tell you, that with his educational background, he's a person who is capable of being successful and properly reintegrated back into society upon his release from custody. I don't mean to insult the court by telling you what you already know, but this is not a violent offense. It is a serious offense to carry, and he does have a history. But it's not a violent offense. And I don't think that there's anything inappropriate in a sentence, a 2-year sentence that does not involve incarceration in a state prison. Although these are drug offenses where he's alleged to have been in possession with the intent to distribute these drugs. And I say that it's a trafficking, but what I'm saying is that he's alleged to essentially be a distributor of drugs as opposed to a user of drugs. He does have a drug problem and has for some period of time. He is what you have seen before, a person who supplements his drug habit by being involved in the drug trade. When we came here when we were supposed to come here, when we did come here the last time for the hearing, I may have mentioned to the court, or would have mentioned to the court, that Sober Living America is a facility that has several locations here in the metro area, an inpatient treatment program that I would have asked the court to release him to. He'd been interviewed, he'd been accepted. It was a 12-month program. He would have been eligible to go there and have his substance abuse issue addressed. And that is still an option for him. I've not spoken to the director since the last time we were here, but I'm certain that based on his previous qualification that he could. So I'm asking the court to, of course, you're going to revoke him for 2 years, but consider letting the balance of the 2 years that he hasn't served thus far be served in the Sober Living America facility. If the court's not inclined to do that, I'd ask that you consider perhaps ordering that he, to the extent that you can order it, the balance of that 2 years be served in a transitional center, a Department of Corrections transitional center. There are a number of them throughout the state. It is a custody situation that he would be in. And as you know, of course, we've got other fish to fry, if I can use that euphemism. I don't think it's an inappropriate ask. And so I'd like you to give consideration to one of those two things, Judge. So whatever you decide, we're ready to move forward.
Okay, I appreciate that. I appreciate all that additional context. Mr. Hand, what do you want to add to the equation?
Judge, I just want to say that the state doesn't think that his drug use is the reason why he got the charges or he was charged and arrested. And so the state is not opposing it, but it's certainly not supporting that being the outcome here, Judge.
Okay. Well, I don't need to decide that part. It may well be that drug addiction contributes to involvement in drug trafficking, sales of drugs. That is the part that concerns me the most. Mr. Chappell, you may need help with addictive behavior and hopefully you'll get it. The concern that I have is that the way you get involved with drugs is very much other affecting. It's not simple possession, and we're working through the impact of the drugs on you, but we're working through the ripple effect of making available to other addicts these drugs. And I don't know anything about the new charges. You are merely stipulating that you were arrested for them, but you're trading up in quantity and quality, by which I mean now it's trafficking in heroin. And so no violence here, but death follows in your wake. People overdose on these things all the time. And that's the risk that I think you pose to the community. You may have a risk to yourself because of product that you use, but it's the product that you get out to others. And it may not even be directly. You may be in the middle of the chain and you're selling to someone else who's selling at the street level. But you're in that chain of commerce that is very dangerous to folks. And the part that concerns me is that you got back into it. These cases are old. I was not a judge when you had these three cases. And it sounds like for a while you got out of the mix and got a degree and were doing other things. Something pulled you back in. Your drug use, the money, the lifestyle, I don't know what it is, but you need to figure out a way to stay out of that line of work because again, you're not shooting anyone, but what they are shooting up as a result of what you're selling could lead to lots of folks getting hurt pretty badly. And I think it's important that I take some steps that discourage you from doing that. So with that, I do find through your stipulation, not an admission, but your stipulation that you were arrested for trafficking in methamphetamine, heroin, and other illegal drugs in Fulton County in July of last year. That serves as a sufficient basis for me to revoke your probation. I will do that to the tune of 2 years in each of your three cases. Trying to find your three cases in 08 SC 67957. I will revoke 2 years and suspend the balance so that when you are done with your revocation, in that case, That case is closed out. You will get credit for all 3 cases from July 31st of 2021. In 11 SC 100815, I will revoke 2 years and suspend the balance. And then in 11 SC 102392, again, 2-year revocation, but I will reinstate the balance. It will be a special condition of your probation that you submit to random drug and alcohol screens once a week for the first 6 months of that probation when you're back on it. And then probation can determine the frequency of the random drug and alcohol screens after the first 6 months of the remainder of that probation. I will recommend to the Department of Corrections and or the Department of Community Supervision, whoever is responsible for housing you, that you be considered for a transitional center. They do exist. Regrettably, there are fewer of them than there used to be, certainly fewer than there need to be. But because of the nonviolent nature of your offenses, it may well be that the Department of Corrections decides that that's the right place for you to go to transition back into the community. You do have support in the form of family. Don't let them down when you get back out and get back into this line of work. There are more chapters you're going to need to work through, Gwinnett, Henry, and then obviously this unindicted case. And from what Mr. Adams shared, there may be some steps you can take that will reduce the footprint of this unindicted case. But that's got to get pried out of the indictment unit of the DA's office before a whole lot can happen with that. Mr. Adams, anything else in connection with Mr. Chappell's 3 cases?
No, Judge, nothing further.
Mr. Hand?
No, Your Honor, I would just ask that Officer Brooks be excused.
Almost. He'll be excused in just a sec.
No, Your Honor.
Ms. Tucson, do you need anything else to complete those 3 revocation orders?
I don't believe so. I wrote everything down. I don't believe for that last one for 11 SC 102392, everything will be submitted on the order with the exception of the housing portion, because I don't believe probation, that would probably have to go through the Department of Corrections.
Okay, fair enough. I think then that's it. Officer Brooks, thank you for your time. All right. Mr. Chappell, you are free to leave the booth. Thanks for your patience.
Thank you, Your Honor. Thank you, Your Honor.
All I have, no excuse.
Yes, sir. Appreciate you being here and your persistence on this one.
Good to see you, Judge. Good to see you.
All right. Let's turn at long. That's loud. Let me mute that. Okay. To Mac Ransom. And he is 16.5 South. Mr. Ransom, can you hear us? Great. You are a little hard to hear, but I don't think you're going to need to be saying a whole lot. Mr. Melnick, let me add you to the mix. We're not seeing you, but you're on the screen. Can you hear us? Mr. Melnick, you there?
You see me? Yeah.
Now we can hear you. We still can't see you. Not sure what the issue is.
Yes.
Yes, I'm here.
No, I know you're around. Your name is on the screen, but it's a black box. Oh, now we can see you now. But you're frozen. Not sure where you are.
Just give me.
We'll give you whatever time you need because you've got the only 2 cases left on the calendar.
Ready?
Mr. Hand, are you handling both these bond hearings?
Yes, Your Honor.
Okay. Great. Mr. Ransom, you can still hear us? Booth. I got the wrong booth. You're in booth 2. Stay where you are, Mr. Ransom. There, that's better. Can you hear us?
I can hear you, sir. And I can't see nobody.
All right. Well, we're going to try to get Mr. Melnick plugged in here.
So, yes, sir.
Mr. Melnick, any luck?
Mr. Hand, can you hear me?
I can.
Yep.
Okay. All right. Well, I'm at the Clayton County Courthouse right now. And apparently they're having some network issues. So,
Yeah, it's pretty choppy. You keep freezing. I don't know. So, Mr. Melnick, I don't know if you can hear us, but your feed keeps freezing up. I don't know that we're going to be able to have a meaningful bond presentation from you on behalf of either Mr. Ransom or Mr. Lloyd. Do you have a plan B?
Judge, how is this?
Well, hold on. I don't know. It looks a lot like the last one. But so you're on twice, which I don't know which one I'm supposed to.
So Judge, I logged off and then logged back on.
Okay. I think I see you. Let me remove. Well, that can just stay right there. All right. What is happening differently now that we should be confident it's going to work?
Ask the people that run the courthouse in Clayton County, Judge. I'm on their public Wi-Fi. I was trying to go on through my phone and that was not doing very well either. So
all right. Well, it's working now. So let me cut you off. And while we can hear you, let's start with Mr. Ransom. So this is position 16, 20 SC 180102, State versus Mac Ransom. Mr. Hand is here in court for the state. Mr. Melnick is appearing remotely from Clayton County, and Mr. Ransom is at the county jail in Fulton County. And this is a bond hearing. I read Mr. Melnick's motion where he points out, now that he's learned more about the case from reviewing discovery, some apparent peculiarities in the evidence about the allegations, and that perhaps it is time to revisit the question of bond for Mr. Ransom. Before you dive in with your presentation, Mr. Melnick, Mr. Hand, did you have a chance to review Mr. Melnick's motion, and have you and Mr. Melnick talked about bond?
Your Honor, I did speak to him this morning, and yes, I have had an opportunity to look at the motion, Judge.
Okay. Are you opposing the motion?
Yes, Your Honor.
Okay, then let's go forward. Mr. Melnick, when you're ready.
Thank you, Judge. So just so you're aware of where we are procedurally, Mr. Ransom has been in jail since January the 7th of 2021. So he's been in jail for an extensive period of time. We did have a bond hearing, not in front of you, but in front of Judge Borski, where bond was set in the amount of $85,000. But unfortunately, Mr. Ransom has not been able to post that bond as we sit here today. He is 46 years old, Your Honor. He had been gainfully employed prior to his arrest, but obviously with the length of time that he has served, I don't believe that he still has that same job that he had prior to his arrest. Your Honor, Mr. Ransom has significant health issues that are not being adequately addressed at the jail. He has a severe diabetes. He also has glaucoma that's going to require surgery in his eyes. And I don't believe that the jail is adequately able to address that. I'm sure that the taxpayers do not want to pay for that surgery, which is a surgery that I'm actually pretty familiar with because both of my parents have had it. So, Your Honor, turning to the facts of this case, and I'm not actually telling you anything that is not in the body of the arrest warrant itself. The allegation is that the alleged victim, Mr. Hendricks in this case, drove from his home in Lawrenceville to go grocery shopping, purportedly at the Kroger off of, I think it was off of Campbellton Road, which I mapped it out is about a 45-minute drive or so for Mr. Hendricks to go to Kroger. And he alleges that while inside the Kroger, Mr. Ransom approaches him, and Mr. Ransom purportedly tells him that he has a gun and that Mr. Hendricks better do what he says. So with that apparent knowledge, Mr. Ransom and Mr. Hendricks then walk out of the Kroger, get into Mr. Hendricks' car, and by Mr. Hendricks' version of these events, drive around for the next 3 hours purchasing drugs and drinking and encountering prostitutes. And subsequently, Mr. Hendricks goes to the Chase Bank. And I'm sorry, Judge, it's several miles away from where the initial contact took place, but I don't remember exactly where it is right now. Mr. Hendricks goes in the bank. He does not call 911. He just tells a bank teller, excuse me, that there's a person in his car who's making him withdraw money from the bank. Mr. Ransom obviously disputes all of that. What Mr. Ransom says is that he was approached at the Kroger by Mr. Hendricks, and they were together voluntarily for several hours doing drugs and doing all kinds of things, in all honesty, and that Mr. Hendricks is fabricating this story because by the time he got to the Chase Bank, he had basically run out of money, could no longer use his ATM, and had no reason to explain to his wife why he had been taking all this money out of his account. I will also point out that it doesn't appear that they ever pulled any video from the Kroger. And when Mr. Ransom was arrested in Mr. Hendricks' car, he did not have any firearm or any sort of firearm replica or anything along those lines. So, Your Honor, Mr. Ransom is originally from Blakely, Georgia, which is Early County, down kind of near that Thomasville area, near the Florida Panhandle. Mr. Hendricks, I have learned, lives in Lakeland, Florida now. So he lives about 8 hours away from here and many hours away from where Mr. Ransom's home is. I expect that that's where Mr. Ransom would go back to if he were to be released from custody. He can live with his mom down there. He actually has a very extended family in that area. His brother lives up here in the Atlanta area. And he does have other family members up here in the Atlanta area. But that's where I would expect him to return to, but he would have no issue with returning here for court. I will leave the issue of Mr. Ransom's record up to pretrial, but I just think Mr. Ransom has spent an inordinate amount of time, in custody on what I can only characterize as a very specious allegation. I think that a bond reduction at this time, now that he's been in jail for 21 months, more or less, I think that it would be appropriate, given the totality of the circumstances. I'm asking that you reduce his bond to a total bond of $50,000, Judge.
Okay, so it would reduce the dollar amount, and I need to reassign it because Judge Borski's bond actually applies to a different set of charges. Same case, but the complaint had different charges than the indictment had. More charges, and frankly, less serious charges than what popped out of the grand jury. Okay, understood. Let me find out from Ms. Gordon what she has gathered in terms of criminal history for Mr. Ransom. please.
Your Honor, the GCIC indicates the defendant has 23 cycles beginning in 1994. The last arrest was December the 27th of 2020 out of Blakely, Georgia for aggravated assault. No disposition listed on the last arrest. The record does indicate 2 prior felony convictions outside the 10-year period. A 2012 felony conviction from Fulton County for possession of controlled substance and willful obstruction of law enforcement officer. A second 2012 felony conviction, Fulton County, possession of cocaine, aggravated assault, and willful obstruction of law enforcement officer. 2013 felony conviction, DeKalb County, for escape, for 2 counts of robbery, and for aggravated assault. Nothing further to add, Your Honor.
Thank you, ma'am. And Ms. Tucson, no active probation for Mr. Ransom?
No, Judge. His probation literally just expired about 3 weeks ago. So he's not on active probation at the moment.
Well, that spares him revocation. All right, thank you. Mr. Hand. One last question for Mr. Melnick. In your motion, you put something about the brother. Was it Mr. Hendricks's brother who ought to have been calling because Mr. Hendricks drove away, leaving his brother behind? I mean, that was part of the story, was that I was grocery shopping with my brother, and there's no call from Mr. Hendricks' brother saying, hey, by the way, some guy and my brother just drove off.
There's no such call, Judge. That is correct.
Okay. Mr. Hand.
Yes, Your Honor. As stated, Your Honor, the state does oppose reducing the bond. I believe it's at $85,000, but as you stated, that applies to Judge Borski's bond order, which has a different set of charges that weren't actually indicted. Your Honor, the state's opposition is mainly on the likelihood of reoffending. As you just heard, the defendant has an extensive criminal history. I note at least 7 felonies in 23 cycles, Judge. Also, danger to the community. We heard that there's a pending aggravated assault charge that's open as well. And this case involves at least the perception of a gun. The victim, as stated, is no longer in the state. So, danger, particularly to him, may not be at play. However, danger to others in the community still remains. I understand that Attorney Melnick seems curious about some of the facts that are alleged. I would say that that doesn't go to the Ayala factor of danger to the community. What we have here is that the defendant did, at least was perceived to have a gun, and then took the victim's car, fled in that car, got into an accident, and then fled on foot after that.
So that's a piece I didn't get. So what Mr. Melnick was describing is that Mr. Ransom and Mr. Hendricks may have driven around together for a while, as I wrote down, getting high and getting ladies. And then at some point, Mr. Hendricks went into a bank to say this bad thing is happening. And what you're saying the evidence would show is that Mr. Ransom actually took the car, drove away, crashed, and then on foot tried to get away.
Yes, Your Honor.
Okay.
And also I'll add that Mr. Hendricks is, at the time he was about 71 years old. Now he's 72. An older gentleman, was certainly overpowered by the defendant here, feared for his safety, and just did what he was told to do in order to get somewhere safe, where he could walk into a bank and tell someone to call the police. And that's what he did. Yep. The allegations, I think, are sufficient for the court to acknowledge the danger to others as well as reoffending, and to not lower the bond below the $85,000.
Got it. Thank you. Mr. Melnick, remind me, if Mr. Ransom were not to go way down to Bleckley County, but to stay up here, he'd stay with his brother. That's an option his brother is making available?
Yes, his brother lives in Decatur.
Decatur, okay. All right. Okay, well, I need to modify the bond anyway so that it's a bond that applies to these charges. I will do that. I am going to set the bond at, let me make sure I get the math right. It's going to be 20,000 for count one, 20,000 for count two, and then 15,000 each for counts 3 and 4, which should get us to a $70,000 bond, 70. That will be through the sheriff's 10% program. Mr. Ransom, if you are able to post that bond, you will be initially subject to pretrial supervision level 3. That is the most restrictive as we make sure you're sticking around. You will be required to wear an ankle monitor that the county will pay for. And you will at least initially have a 24-hour curfew, meaning you'll reside at your brother's house. And Mr. Melnick is going to need to get that address to Ms. Nelson, who is on my staff, so that that's baked into the bond order that you reside at your brother's address. I'm happy to lift the curfew for purposes of work. So if you can document that you've got a job, not just say you've got it, but document it, and the hours are noon to 6, then you can be out of your brother's house from 11 a.m. to 7 p.m. So you can get to work, do your job, and get back. But I am going to require you, at least initially, to be living here in the metro Atlanta area. If for some reason that proves problematic for you or your brother, Mr. Melnick can always petition to have that shift down to Bleckley. That's just further away, and I just assume you stay more local as we move forward with this. But I'm striking a balance between what Mr. Melnick is asking for and his version of the facts and your criminal history, which suggests you have struggled with law enforcement issues in the past. I will note that your 3 most recent convictions are not recent. They're 10 years ago. And so the other 4 must be even older. And so you may have turned a corner of sorts about a decade ago. But then there was this. And it may be that you struggle with drug use. I don't know. That may be part of what needs to be done to help you avoid this happening again as you approach your 50s. But that's the bond that I am comfortable setting. Let me see. There'll be no contact with Mr. Hendricks either, but that should be pretty easy because he's moved away. And that is how I'm going to leave it. Mr. Melnick disappeared on us. And make sure he can still hear.
I'm back.
Okay, you're
Sorry
back.
about that. It was another technical glitch, but I'm here.
Okay, you've switched personas again. So let me remove this one and add this one. Whoops, add spotlight. There you are. Okay. Mr. Ransom, do you have any questions about the bond that I've described?
No, sir.
Okay. Mr. Melnick knows that if the bond I've set remains out of reach for you financially, and this case doesn't move to trial, he will get back in front of me saying, it's been more months and there's no closure for Mr. Ransom. Is there any reason, Mr. Melnick, we cannot move Mr. Ransom's case to a trial calendar, regardless of bond?
No, it can be moved to a trial calendar, Judge.
Mr. Hand?
No, Judge.
Trial it is. So this will appear on an upcoming trial calendar. And Mr. Ransom, you will either appear at that trial because we bring you over from the county jail or because you've made bond and you'll show up wearing your brand new ankle monitor. That ankle monitor will, if I didn't say it, be paid for by the county, at least initially, and we'll take it from there. Anything else?
I had one question for you.
Yeah.
Hold on, Mr. Ransom. I know you had announced that it would be through the 10% pretrial program. Can it be either through the 10% program or through a bonding company or exclusively through the 10% program?
Let's start with 10% because that guarantees pretrial. Pretrial won't be involved if it's through a bonding company. If time passes and that is a dollar amount outside of Mr. Ransom's family's reach, then what I can do is make it some of the counts would be through 10% and thus get us pretrial supervision, and the others would be through a bonding company.
And just for Mr. Ransom's knowledge, so that his family knows, and I'll explain this to them a little bit later, going through the 10% program actually means that you get the money back once the case is closed. So that's a real benefit of doing it that way. Just so you're aware of that, Mr. Ransom.
Right. It often encourages folks to pitch in because they know they're going to get their money back. So we'll see how it plays out. Mr. Ransom.
I go through a bonding company bond up?
No.
Yeah, right now it's through the 10% pretrial release program. I know you're gonna call me a little bit later, Mr. Ransom. I'll explain all this to you. Okay?
I got to pay, what I mean, I pay $7,000
That's correct.
to get out of jail?
Yes, sir. And you gotta wear an ankle monitor.
So how much I got to be to get out of jail?
$7,000.
So you and Mr. Melnick will talk about that, and if we need to meet again, we'll do it, okay?
Yeah, what happened to the bond I just had, the bond company bond?
Well, that was a higher bond, Mr. Ransom. Mr. Ransom, we'll talk about it, okay?
I just lowered the bond. Okay. All right. Thank you.
All right.
So let's go to our final case on the calendar, Mr. Lloyd. And let me unmute him. Mr. Lloyd, can you hear us?
Yes, sir.
Great. All right. You have two cases with me, Mr. Lloyd. The one that is in front of me right now is 22 SC 181-130. Charges you with aggravated assault and possession of a firearm by convicted felon, a couple other counts. I'm gonna look up your other case just while we're working through this to see what the charges are. But Mr. Melnick has filed a motion for bond. We're going to talk about bond, and I'll let you know what I'm going to do about bond. So why don't we get started?
Judge, we had started a bond hearing in this case, and I was trying, to find the date that we did that, and it was, we sort of paused it because the state contended that there were some jail calls that were pertinent. We did it on August the 31st, Judge.
I see that. Yeah.
I don't know if you need me to go through everything again, or if you want to just pick up from there. This was a case, it involves obviously it's a domestic case, Judge. There was an issue about a 2012 matter where the state had originally charged Mr. Lloyd with possession of a firearm by a convicted felon based on a 2012 first offender case that he had. And I think we determined on August 31st that he is not a convicted felon. So he has no prior felony convictions. It took us a little while to kind of get through all that because there had been a revocation on the 2012 case, but we determined that it was Judge Carnicel. Judge Carnicel did not revoke his first offender status, and he completed first offender on that case.
That's the robbery?
I believe that's correct, Judge.
Okay, I'm just looking at the notice of aggravation. It lists a 12 SC robbery, and you're saying that was the first offender, which would mean then that the charge in this indictment about felon in possession isn't something the state would have a lot of success in prosecuting.
That's correct, Judge. As far as I know, Mr. Lloyd is not. If that is that I believe that was the predicate offense on that count of the indictment, and if that is I have it here. If that is in fact the case, then the state won't be able to prove that.
Okay, not the most serious charge in the indictment, but it is in there. Okay.
I think it's pertinent to the issue of bond that he doesn't have a prior felony conviction.
Okay.
So that was why I was getting into all that.
Got it. Okay. So what more should I turn to Mr. Hand to say where the jail calls, or what do you want to have happen now?
So I talked to Mr. Lloyd about the jail calls, and he does not deny that when he first got arrested, he reached out to the victim, the alleged victim in this case, but he denies that there was any effort at intimidation or any effort to try to intimidate or I'm sorry, the words aren't coming to me right now, Judge, to try to influence her testimony or anything along those lines. Beyond that, Judge, I mean, Mr. Lloyd has very strong ties to the community. You had commented the last time that we were here that Mr. Lloyd's mother, whose name is Kathy Holliday, has been to every single court appearance that he has had. He has a place to live with her in Riverdale, should he be released from custody. And other than the robbery case, which is, he has been discharged under the First Offender Act, Mr. Lloyd doesn't have any real significant prior history that I'm aware of anyway. And so, Your Honor, like I said, we had already kind of gone through all that to some at some length at this last bond hearing.
Okay, so remind me then, I'm looking at the other case, which has some serious charges as well. You don't represent Mr. Lloyd in the other case. It's kidnapping and aggravated assault and family violence. There's no bond in that case either. So isn't setting a bond here a little bit of a exercise as opposed to an outcome determinative event?
Okay, so Your Honor, I'm looking at his jail screen right now. And the only charges that I see that are holding him with no bond are aggravated assault and battery from December 29th of 2021. I am aware of the other charge that was, I believe, that involved an incident from February the 8th of 2021. He seems to have originally been charged with 2 counts of terroristic threats and simple battery. And he was released on bond for that. I also, the victim in that case is deceased. In the last time we were calling it the second case, but it's a case that actually predates the case that I'm representing Mr. Lloyd on.
So the case I'm looking at, the alleged victim is Ashanti Scott.
Yes.
You're saying she is deceased?
That is correct, Judge.
Okay. And not as a result of whatever is charged in this other indictment, which actually dates back from September of 2019. So it's 3 years ago.
Okay. Oh, I see it. It was originally charged as aggravated assault and family violence battery.
Yep. And it got upgraded.
Yes.
Okay. But I don't see a bond on any of that. The aggravated assault and family violence battery do show all the magic numbers, OBTS, et cetera. So I don't know if this was a direct, I guess it would have to be a direct indictment because it came almost 3 years later. So.
Yeah. I believe Mr. Whitenauer was handling that case for the state. There was some talk about it the last time we were here, Judge, and he said that he was going to investigate the cause of death of Ms. Scott, and assuming that the cause of death had nothing to do with this incident, which it didn't. She died, I want to say, earlier this year from some sort of heart condition, apparently.
Okay.
Yeah, completely unrelated to this. That he was going to. I mean, I don't see what stake to go forward on the case at that point. In all honesty.
All right. Well, let's find out from Mr. Hand what's going on with both cases. We've got 2 sets of charges, no bond on the direct indictment, but I don't know. We need to work through that with an allegedly deceased victim, and then this case as well.
Yes, Your Honor. So for the other case, that's correct. Mr. Whitenauer is handling that case, and I don't have much information about it other than that victim is tangentially referenced in this case as well.
Okay. Do you have enough information to know whether Ms. Scott is deceased?
Yes, Your Honor, I can confirm that.
Okay. So that's a case the state's still proceeding on?
As my last conversation with ADA Whitenauer is that we are still proceeding with that case.
Okay.
And so I do believe it would be in a no bond status currently.
Okay.
For this case, Your
Is
Honor,
this case also in a no bond status?
no, oh, yes, it is. My apologies, Judge. Yes, this case is.
Okay.
Your Honor, from my conversation with ADA Charles, who previously handled this, in the last bond hearing on 8/31, where this was interrupted, the purpose of it being continued, I guess is the best word, is so that Mr. Melnick could review the jail calls that were referenced.
Yep.
In an email this morning, Attorney Melnick represented to myself and Ms. Charles that he had not had an opportunity to review those calls. They were shared with him on September 6th, some via Dropbox because they were too big, others via evidence.com. So the state is here and ready to share those calls. I'm not sure if Your Honor wants to proceed, considering Mr. Melnick has not had an opportunity to hear them, but we do contend that they demonstrate a intimidation of the witness. The witness is clearly, making statements during those calls that, she doesn't do what she is expected, that she's going to wear an ass whooping is her phrase. The defendant admits, doing what he had done because he loved her in some way. So there seems to be a relationship of abuse, but then affection when the victim is doing what he wants her to do, but when she's not, he's angry, and other stuff. But we're here prepared to move forward if you want to hear those calls. They're each about 14 minutes long. I have selected about 6 of them. There are 2 that are most important. I can key in on those, Your Honor, and just play the pertinent parts, but that's for the court.
Okay. So Mr. Melnick, what I understood you to say is that you and Mr. Lloyd had discussed the calls, and Mr. Lloyd acknowledged that at some point he may have made some calls that didn't reflect real well on his ability to maintain boundaries. Those are now my words, not yours, but that's the essence of what I got from you.
So there were calls that were made. There's no question about that. So of course it's a call from the jail. And if he's calling the victim in the case, she can obviously not accept the call, and that would be the end. There would be no further conversation at that point. I don't deny that there were calls made. So what was sent to me was about 60 jail calls.
Okay.
And it's kind of hard for me to sort through all that and figure out like what I need to listen to and what I don't need to listen to. I spoke to Mr. Lloyd about it, and he said that he, whatever calls were made, he was never ever trying to threaten or intimidate her. That the nature of the calls were, why are you doing this to me? Essentially, like I didn't do anything to you. Why are you doing this to me?
And what is the connection that your client has to Ms. Jackson? Ms. Jackson is the alleged victim in the case you're handling.
They were romantically involved at one point, Your Honor, but obviously that ship has long sailed, given Mr. Lloyd's 10 months in jail.
Okay. No kids together?
No.
Okay. And what was Mr. Lloyd's alleged connection to Ms. Scott?
They had also been romantically involved with one another at one time, Judge.
Okay. Got it. Well, my thought is if Mr. Hand can get to me the calls of greatest interest and then could let you know, Mr. Melnick, of the 60 you got, and I appreciate them giving you a lot so you don't feel like you didn't get everything. But it sounds like there are a handful that I could listen to and you could listen to, Mr. Melnick. Then I can decide if there's really much more we need to talk about, that this is much ado about nothing, or having heard those calls, Mr. Lloyd is precisely where he needs to be until this case is resolved. I'm happy just doing the listening in chambers. It'll be easier to do it that way. But that is a proposal. If Mr. Melnick, you want it to be aired out here in court, I'm fine doing it that way.
Mr. Lloyd, you seem to be in agreement with that. You okay with the judge hearing the conversations? Yeah, so here's the way that's going to work procedurally. Mr. Hand is going to play for me the conversations first. And then I'm going to make sure there's nothing in there where you say something like, geez, I really hate that Judge McBurney. I can't stand him, or anything like that. And then as long as there's nothing in there that I don't that I think would be just sort of extraneous or, it's not relevant to the issue that is whether or not there's any witness intimidation or anything like that, then I will say, okay, now you can go play this for Judge McBurney. You can forward this to Judge McBurney, and Judge McBurney will then make a decision about bond. You okay with that?
Yeah, I know there's nothing in there.
Okay.
Okay. All right.
Then why don't we do that? So you will let Mr. Melnick, you apparently, Mr. Hand, have identified, you call them some highlights. You can let Mr. Melnick know what those are, so he can, when he is not stuck at low bandwidth Clayton, listen to those. And as long as he says, sure, I don't mind you sending that on to the judge. I mean, he may be clear. He may identify some points. If you disagree with him that, wait, the judge needs to hear that as well, we can discuss sort of the generic of what the content is to decide whether I should hear it or not. But if he said it, I don't know why I can't hear it. But I understand Mr. Melnick's point, and he'd just like to preview them first. And then you can, via Dropbox, whatever is easiest for you, you can give me a thumb drive, include in there the pertinent parts. I don't need to listen to all 60 calls either.
Understood.
That would be helpful. Okay.
Judge, how do you want to do this timeline wise? How do you want me?
Well, we're done. And you're going to let Mr. Melnick know. I'm not going to make folks, we've got all sorts of people plugged in here. So I want to give Mr. Melnick an opportunity to listen to them where he can clearly.
Okay.
And then I'll work at Mr. Melnick's pace. He's the one who is working to get his client a bond in this case. So you'll highlight for him before you leave work today via email. Hey, call number 7, the last 3 minutes. Call number 14, the first 2 minutes. Whatever it is that you have found is most salient to your point. And Mr. Melnick can listen to those and say, great, share that with Judge McBurney. If he pushes back on some, maybe you guys can agree. If you can't, then the ones you can agree on, let me know. And the ones you don't agree on, you let me know why you don't. And I'll say, no, I want to hear that as well. Or I don't, that part I don't need to hear. I understand why Mr. Melnick doesn't think it's relevant.
Yes, Judge.
Okay.
That makes sense.
All right. Does that work for you, Mr. Melnick?
Absolutely, Judge. Thank you.
The last thing I'd ask, and then there's someone in the audience that I'll hear from real briefly. I would ask you, Mr. Hand, to get with Mr. Whitenauer so that he can let me know what he thinks the stat, and he can send the email to Ms. Nelson and to me.
Okay.
But there's no lawyer on the other side right now for Mr. Lloyd. What he thinks the status is of bond in his case. Because what I don't want to do, if I decide, hey, it makes sense for Mr. Lloyd to have this bond such that if he made it, he'd be out, for him to run into the brick wall of the other case. Mr. Melnick does not represent Mr. Lloyd on that one, so he doesn't need to be included in that exchange. But if Mr. Whitenauer thinks it's in no bond status, I don't know that that's what the docket shows, and so he may need to file something to make that happen. And frankly, let me go back to that case.
And Judge, can I correct something that was stated earlier by Attorney Melnick? I just want to make sure it was clear that.
But yes, you may, but not quite yet.
Okay.
So, Mr. Melnick, you received a scheduling order in the other case. I don't know if you said something at plea and arraignment that prompted my team to think you were on the case ending in 917, but it's moving forward. There was a plea and arraignment on the 31st when we had the bond hearing in the case on today's calendar. And then there's the scheduling order. So
what's that case number, Judge?
22 SC 182917. You have not filed an entry, so we're clear. I'm not saying that you own it, but there's the scheduling order that went to you. So if you're not in that case, we're going to need to get Mr. Lloyd in here to figure out what's going to happen with representation.
Okay. I'm still trying to figure out how the state's going to prosecute the case. without the complaining witness, but I'll.
Right. It's a great question, but you aren't the right person to talk to Mr. Whitenauer unless you're Mr. Lloyd's lawyer on that one.
I'll talk to Mr. Lloyd's mom about it.
Okay.
See if we can make arrangements for that.
Sounds good. Ma'am, did you have something you wanted to say? Ms. Rivers, you don't need to take this down.
My son, this lady doesn't have a phone number. She's been calling me. My daughter got text message. She's been calling the whole time he's been there. She texted us. She called me from a private number. She's lying. She don't have a phone. She's a crack. I don't want to use the word, but she's a drug addict.
Okay.
Drug addict. She doesn't even have a phone at all. I know he hasn't been contacting her. I was contacting her in January when it first happened. Other than that, I know he hasn't. Why would he contact her, threaten her, and he knows it's recorded in jail? That doesn't make sense.
It doesn't. That's why I'm going to listen to these calls.
My daughter, would you like her to read this? She's been contacting his son.
I don't, but what you want to do is share that with Mr. Melnick, so that he's got it. He's the right guy to share that stuff with. Okay.
You know that she's been
Okay.
contacting us.
I hear you. And Mr. Melnick, he gets all that. He can talk with the prosecutor about it because really the prosecutor needs to be rethinking the case if something like that is happening. And if Mr. Melnick thinks it's appropriate for me to get in that mix, I'll certainly hear from him on that. Okay.
All the time, he stayed away from her. She kept contacting him. I miss you. I love you. He tried to stay away from her. I don't tell you, live with me. He wasn't around her at all. It's her. She has busted out 2 car windows, knives and hits.
Okay.
With bricks.
Got it. It sounds like a very animated relationship. All right. So that's the plan. Mr. Melnick, please do talk with Mr. Lloyd's mom about the case ending in 917. Because Mr. Whitenauer is going to let Ms. Nelson know what he thinks the bond status is in that case. And I'll look for an email from Mr. Hand that will be copying you after the two of you have worked through what calls you want me to hear. And it may well be after some of these discussions, folks are in a position, even more importantly, to see if we can work the case out. We'll see. Do you have all the discovery in the case you are an attorney of record on? I mean, can we move this? I know we're talking about bond, but to your point, it's been sitting around for a while. Can we move it forward?
We can, Judge. I received discovery from Mario Cladis.
Yep.
And it was just paper discovery. Miss Charles sent me the phone calls, and I'll have to go back and look in the evidence.com directory and see if she sent the body camera. But that would be the only thing that I may not have is the body camera, which I think would actually be very relevant to the case.
Sure.
When Mr. Cladis, I remember I'm actually looking at the email from Mr. Cladis right now. When he emailed me the discovery, which was right before we had this bond hearing, or not too long before we had this the first bond hearing, he said that the written discovery was all that he had. So I don't know if I've ever gotten the body camera in this case.
All right. Well, you and Mr. Hand can talk about that as well, because I want to make sure you've got everything. At some point, I'm going to be done with bond, and either there's a bond or there's not. And then we need to make sure we work through Mr. Lloyd's cases. He's got 2 of them. And if the state isn't going to null pros the case with the deceased victim, which they don't need to, there are ways to be creative there, then we need to get Mr. Lloyd into court. He has managed in 2 different relationships to pick up real serious charges. That to me seems more than a coincidence, but I remain open to see what's going on with both these cases. I will let you know what's going to happen with bond in the case ending in 130 after I listen to the calls, and we'll see what we do with 917 after Mr. Melnick, you decide whether you might get in that case, and Mr. Whitenauer lets me know what he thinks is happening with bond. Mr. Hand, anything else from the state?
Not from the state, Judge.
Mr. Melnick, anything else?
Not at this time, Judge. Thank you.
All right. Well, thank you to Clayton County for getting their Wi-Fi fixed. Ms. Livingston, thank you so much for getting everyone. They were exactly where you said they would be. This worked real smoothly. I appreciate it.
You're welcome, Judge. Thank you.
Yep. And thank you, Ms. Tucson and Ms. Gordon for providing this background information, and Ms. Rivers for all the takedown.
Okay, Judge. See you tomorrow.
Thank you.
All right. See you, everyone.
All right.